I'm going to go ahead and get us started. I would like to give a very warm welcome to people from all over the world, whether it's your morning, your afternoon, or the evening. Thanks for spending some of your day with us. My name is Leah Wing, and I'm the co-director of the National Center for Technology and Dispute Resolution. It's the birthplace of ODR thanks to the brilliant work, the visionary work of our director, Ethan Katch, who joins us here today. And the center that he created has been the host of 19 years. I counted this as a 19th year, consecutive year of ODR forums. It's the first one we've had online. And the beauty of that is that we can certainly have far more folks join us, and we're really glad you're here. We've had some years where we've had 2 forums, so I think it's the 22nd or 23rd time we've gathered. And you're going to hear later today about where we're meeting next, and we hope you'll join us for that as well. I want to say on behalf of the program committee, which was Ethan and the distinguished Colin Rule, who most folks know, and Jan Martinez, who I'll introduce again in a moment, and myself, thanks for yesterday. The participation, the engagement in the chat and on Zoom was fantastic. And the presentations that people clearly spent so much time in preparation for were very stimulating. And I want to also thank our keynote yesterday, Abhijit Chavan, who set the stage so beautifully for the conference and the day. And today we have another set of distinguished keynoters that I will leave to our friend Chitu to introduce soon, but we're very excited about today. I wanted to just put a couple things in the chat so that people have access to some resources. First, I want to thank Colin, who spent a lot of time after we all left and had dinner or went to bed or started your day, whatever your cycle of the year was, of the clock was. But Colin spent time editing. And so if you go to odr.info, in the opening blog, you now can access the recordings from yesterday. So thank you, Colin, for all that work. And after today, the recordings from today will also be posted on odr.info. In addition, I would just like to put in the chat some other resources that we think might be useful for folks. As I mentioned, the field has been around for over 20 years, and there's a tremendous amount of literature, academic and practical literature that's already been developed. And thanks to Professor Noam Ebner from Creighton University, a fellow of the center who spent an incredible amount of time collating that. And you can access that for free at over 50 pages of an ODR bibliography at odr.info. So thank you, Noam, for that. And also there's information there if you're putting out a publication or you find one that we somehow missed, please send that to us so that we can add to it. We want that to be a resource for the entire field. In addition, this conference is also really a celebration of the 2nd edition of the treaty's ODR Theory and Practice, put together by Mohammed, Dan, and Ethan with almost 30 contributors. And many of those authors are presenting between yesterday and today. And by attending the conference, you have the ability to access that for a dramatically reduced price, whether you're getting a hard copy or an electronic copy. And so I will also put that in the chat for you. It's to be published in May. And so it's quite likely that you'll need to access your discount when we get a little closer to publication, but we wanted you to have that now since it's only being offered to those that are attending the conference. And I will also say, Colin put in the chat the link for the blog so that you can access the recordings from yesterday. But in addition to that, there are 9 wonderful presentations that people pre-recorded on ODR in Latin America, ODR in the EU, ODR and trust, ODR and sport. There's quite a number there that we highly recommend that you check out. They're also on page 3 of the program, and I'll put that in the chat. So I think the last thing that I would like to do before I introduce Jan, who's going to take the ball and roll with that, is to say that for folks who may be new to exploring ODR or who want to get more involved, We have created a membership organization that's the International Council for Online Dispute Resolution, and I'll put the link in the chat. And Icodr is, as I said, it's a membership organization. We have regular meetings and webinars and activities, experiment with ODR software platforms. And so it's a chance for you to be involved in the growth of the field and contribute your ideas as well. So we welcome you to attend one of those sessions and also to consider being a member. And with that, I'd like to now hand it over to, as Colin said, the queen of dispute system design. We recommend her brand new book that came out that she wrote with colleagues. That's really an incredible compendium of approaches and key things that we should have in mind about dispute system design. So Janet Martinez is a professor at Stanford Law School in California and also the director of the Gould Center for Conflict Resolution. Yeah.
Thank you, Leah. Thank you to all of you for joining us and giving me this chance to share some of my work. I have other fellow design colleagues. Orna and Ethan have written a book also on digital justice and talking about design. And actually Orna wrote the chapter in the new ODR book on system design. So I think it's wonderful that there are so many of us that are trying to look more systemically on the design of processes, one or more. It could be ODR, it could be not, could be only ODR, and how those processes are synchronized in a way to focus on a particular set of disputes for an institution or organization. So I am in under 10 minutes going to share with you, and these will be posted. I'm not going to cover all the material here, but I'll give it to Colin and you can have it for reference later. But I wanted to give us a chance of structuring a lot of the information we learned yesterday in terms of what ODR offers, what ODR even is. And then today we're going to go through a series of really different systems that have been deliberately designed to help us focus on what are we trying to do and who cares. So initially, when we think of design, just to show the expanse, you have public and community justice, courts, claims facilities, something we haven't talked about, but after the wildfires in California last year and natural disasters all around the world, thinking about how ODR could be accessible and useful, I think is a really useful direction of research. We are used to thinking about vendors and suppliers, employment and international cross-boundary commerce. So clearly there are many contexts in which system design and ODR in particular would be relevant and useful. I just want to highlight the fact that often there are already systems in place and there are stakeholders and parties who like those systems the way they are. So sometimes there's a certain resistance to redesign. And I think as we introduce ODR as an option, that we will find often a certain amount of resistance. So thinking about how that redesign can be responsive to the parties and stakeholders. So the framework that we sketched out in my book involves 6 elements that we thought are relevant and important to consider. So I'll just highlight these: goals, what kind of disputes are we trying to capture and address, and what are we trying to accomplish? And I will come back to goals in a second. Stakeholders, who cares, who's affected, who has power? What is the context? Are we in urgent situation, crisis? Is there a culture that has more focus on harmonization and social optimism as opposed to an individual's choice? So both are important and shape really the whole design process and implementation. Processes, clearly, That's where we've been focusing our attention yesterday and thinking about what is the ODR as a process look like, and how can we think about it, and how many disincentives or incentives are there for using the system as it currently existed, and how does ODR link to other formal and more official paths. As I usually say here, resources
45 would be good.
is you can design a Tesla of a system, but you only have a bicycle budget. And so really thinking through what is the capacity for implementing the process, what resources, both financial and human and technical, do you have available? And at the end of the day, is it successful? Are we accountable to the stakeholders and the parties for whom the system is designed? So thinking about ODR in particular, we've talked about a lot of goals yesterday, some of which we started with efficiency of time, money, and information, but access to justice, and I underscore both words there, access to justice and justice. They're both key issues, and my co-author, Lisa Amsler, has written about, I think it was 17 kinds of justice. So really thinking about justice is not a singular concept. So when we say we want to deliver justice, what do we mean? We want to be fair. We want the users to be satisfied. We want them to have choices and agency. The provider may be seeking reputation and credibility, transparency, we talked a lot about yesterday. And so maybe we're just trying to collect data so we can build the algorithm that more efficiently is going to address these issues. So I think the whole notion of goals is critical. And 2 points on that. One is, unless you know what your goal is, you won't know at the end of the day whether you're successful or not. So I think being deliberate in terms of what the goals are is really an important consideration. Second is as we say in the US, it's good, like mom and apple pie, like who can be opposed to mom and apple pie? But the goals very often come at the expense of each other. So what is the priority goal? Is it efficiency? And we really raised that as a question yesterday, to think about, is efficiency the primary marker? Or is it equity? Or is it some hybrid of both? And what are the metrics for addressing all the standards and the values that we discussed yesterday? So I think as we look through the experience in India, the experience with peacemakers, the court system, which we're going to hear about in evaluation, dealing with a disability audience and those users, how do we shape the system and what are the goals and how do we measure them? So I think the last point I wanted to highlight is who is we and who has the power and the control and design? Who designs the system? Is it everyone participating? Is it one party?
Igual a vos, Pablo.
Is it a third party, like a court that said, you go in door 3 and you will get some version of mediation? So one, who designs the system and participates in that process? And second, who gets to choose the process that goes with a particular case? So does the party itself get to choose, or does the court or some independent tribunal tell the party where they're going and what process they will be using? So as I mentioned, I'll post this with Colin, and he's going to put it somewhere where you can access it. And I really look forward to talking to you later today when Amy and I will talk a little bit about some examples in the ODR world and the choices that have been made, the different goals that have been highlighted for each of their systems. So thank you. And I think I'm in my 10 minutes. Leah? Okay.
Wonderful. Thank you so much, Jan. It sets a very important stage for the entire day. So appreciate that. You're sharing your wisdom. And I guess next it's really to hand it over to Chitu to please introduce the keynote. And I guess by way of formal introduction, I will say that Chitu is a fellow of the National Center. She's the founder of one of the first ODR platforms. So she knows all about system design, and she has long experience in the field, decade now, more than a decade now. And she's also president of the International Council for Online Dispute Resolution. So our friend and distinguished colleague, Chitu Nagarajan, please take the stage.
Thanks so much, Leah. And thanks for setting the stage, and thanks, Jan, for that wonderful introduction to your book. Systems dispute design is extremely important. And I think where we are today with this keynote is just to say what India is trying to do. India is actually at the cusp of an ODR revolution. And when I mean revolution, it is a revolution in the true sense. We've seen this for the last 20 years on what has happened all across the globe. But what is about to happen in India can set an example for the rest of the globe to follow. Many initiatives are currently underway to mainstream ODR in India and create a pan-India ODR ecosystem. This is being led by Nithyayog and the Reserve Bank of India. The Reserve Bank of India has announced that ODR should be available for all digital payments. One of the most important statements on how they envision ODR to work for disputes is, quote, recourse to technology-driven redressal mechanisms that are rule-based, transparent, and involve minimum or no manual intervention is necessary to deal with them in a timely and effective manner, unquote. I think that is a very powerful statement. The real potential of ODR is about to be unleashed, and we are all excited to see the first implementation to be rolled out soon of this program in India. Now, the other major initiative is led by Nithyayog. Nithyayog, or the National Institution for Transforming India, is the Government of India's premier policy think tank, providing both directional and policy inputs. While designing strategic and long-term policies and programs for the Government of India, Nithyayog also provides relevant technical advice to the center and states. The governing council of NITI, with the Prime Minister as its chairman, comprises chief ministers of all states and lieutenant governors of union territories. Nithyayog acts as the quintessential platform of the Government of India to bring states to act together in national interest and thereby fosters cooperative federalism. Nithyayog is releasing a pan-India ODR policy framework. We shall hear all about it from our panelists who were responsible for putting this together. Let me state that this was not an easy task. Multiple stakeholders like the government, judiciary, ministries, and industries were looped in to make sure there is acceptance and this works for all. Another important aspect I would like to highlight here is that the true sense of ODR is what the policy framework intends to achieve. Innovative technology to aid in all disputes, pre and post, with a focus on transforming the way access to justice or resolution is delivered. Now I'd like to introduce our panelists for today. Mr. Amitabh Kant, who is our first speaker and who would be delivering his address via a video recording, is currently the CEO of Nithyayog, a 1980 batch Indian Administrative Service Officer of the Kerala cadre. He has been a key driver of initiatives like Make in India, Startup India, Incredible India, and God's Own Country that have positioned India as a leading manufacturing and tourism destination. These campaigns have won several international awards and embraced a host of activities, infrastructure development, product enhancement, private-public partnership, and positioning and branding based on extensive market research. In his capacity as Secretary, Industries Government of India, Mr. Khan drove the ease of doing business initiative and ranking of states on outcome parameters. He is also the author of Incredible India 2.0, Synergies for Growth and Governance, Branding India, An Incredible Story, and the editor of The Path Ahead, Transformative Ideas for India. He is a member of the ODR committee constituted by Nithyayog. The next speaker is Desh Gaurav Sekri, who is here with us. He is the officer on special duty law, Nithyayog, where he heads the access to justice vertical. Prior to his time at Nithyayog, Sekri established and headed the sports law practice at J. Sagar Associates from 2009 to 16, where he also specialized on governance matters. He is the author of Not Out, The Incredible Story of the Indian Premier League, published by Penguin India, and is regular columnist in national dailies. He a dual qualified lawyer. Sekri is licensed to practice in New York and India. He is a convener of the ODR committee constituted by Nithyayog. We also have with us Deepika Kinhal, who is a senior resident fellow at Vidhi Center for Legal Policy and leads his judicial reforms team. She's currently managing multiple projects at the intersection of law and policy with other disciplines such as technology, design, and management to explore solutions to the perennial problems affecting Indian judiciary. In the recent past, she has worked as a part of the Supreme Court of India's E-Committee to envision phase 3 of E-Court's project and assisted the expert committee set up by Nithyayog on mainstreaming ODR in India. She regularly writes in leading print and online media on issues concerning the judiciary and women and child rights. Let us now hear from all our three panelists. Over to you, Colin, to show the video first.
Good evening, ladies and gentlemen. It is an absolute pleasure to speak before all of you distinguished people from across the world tonight on a major policy initiative by the National Institution for Transforming India on online dispute resolution. Let me start by congratulating the National Center for Technology and Dispute Resolution for organizing the 2021 Online ODR Forum. Given how well versed today's audience is with the concept and merits of online dispute resolution, my approach today will focus entirely on contextualizing the widespread scaling of this mechanism as a major policy initiative. Online dispute resolution in India has immense potential for solving disputes outside of the formal court system in an affordable and quick way. The COVID-19 pandemic altered how we function, and while it is a great challenge, it is equally important that we use this as an opportunity, one that helps alleviate the challenges faced by the most vulnerable of its overarching impact. One of the most encouraging developments recently is just how progressive and in fact innovative the Supreme Court of India has been in adopting technology. Indian courts today are quickly adopting leading practices in a sustainable and forward-thinking manner. I'm confident that we are witnessing a visionary period in the history of India's court system. The pandemic has forced a shift towards solutions that minimize contact and can be activated through technology, including for resolution of disputes. Progressive and disruptive changes in justice delivery are critical components that can alter the course of access to justice in an unprecedented way. Each arm of the Indian system is working towards a solution-driven future, and that is where behavioral change is most visible. Advancement of transformative technologies like artificial intelligence, big data, machine learning, and blockchain can be increasingly embedded in legal processes. Honorable Justice D.Y. Chandrachud, who leads the E-Court initiative of the Supreme Court of India, has on several occasions positively spoken about ODR and how it could be a vital cog in combating the clogging of courts. Under his leadership, critical changes are already noticeable, such as introducing e-filing of cases from anywhere in India, making it available 24/7, which is nothing short of a game changer. Indian courts today are quickly adopting leading practices in a very forward-thinking manner. A quote from one of his addresses has resonated since I heard it, that we must, and I quote, that we must look upon justicing not just as a sovereign function, but in the world of technology as a service which is provided to the community, unquote. Nithyayog, seeing the potential of online dispute resolution as a first opportunity to provide access to justice, has taken the lead in formulating an action plan for online dispute resolution in India. In this context, Nithyayog established a committee chaired by Justice A.K. Sikri, retired, to formulate an action plan for online dispute resolution in India. Members of the committee included several of the most senior bureaucrats of the Government of India. Though the committee's online dispute resolution report and further actions, our hope is that we put in place an action plan that not only enables it as an actionable framework now, but also one that adapts and endures the test of time for it to become an option of first recourse for several categories of claims in a dynamic fashion. This committee has tasked itself with creating a framework for technology-led dispute resolution, which assists the formal court system and lays the groundwork for a scalable and adoptable mechanism that stands the test of demand and time requirements. We have several actionable outcomes based on this report, and we will take forward with stakeholder support and participation. These are truly exciting times for technology towards access to justice and justice delivery. Ladies and gentlemen, online dispute resolution in India is at a pivotal cusp. A collaborative mechanism provides the potential to resolve a substantial percentage of disputes at the site of their occurrence without burdening the court. I'm happy to note that the report has been extremely well received by the stakeholder ecosystem, not only in India, but by international experts, many of whom are in this distinguished audience today. The report is the outcome of very extensive and diverse stakeholder participation. A robust ODR ecosystem in India will have high potential to reduce the load on courts by resolving high volume of disputes outside the court. And secondly, gaining access to justice and ease of doing business by making dispute resolution cheaper, quicker, and most importantly, equally credible as conventional methods. The Government of India has been working relentlessly to advance ease of doing business and ease of living. Online dispute resolution is at the focal point of these two missions. Going forward, Nithyayog, in collaboration with the line ministries, civil society organizations, policy think tanks, industry representatives, and of course, international expert organizations like Icodr, will continue to work on ODR from an awareness and capacity building perspective. I'm delighted that today's event showcases the work in online dispute resolution as a collaborative exercise and sets into motion the use of technology towards efficient and affordable access to justice in our post-pandemic response. The support of the global dispute resolution community is appreciated and will be constantly called upon during our rolling out online dispute resolution as a viable multifaceted dispute resolution module in this new normal. I'm glad also to see that the work we are doing in India is being recognized across the world. This will only encourage us more to do the best we can to broad-base online dispute resolution. Thank you very much, ladies and gentlemen. It's been a real delight to participate.
Thank you, Mr. Kant. You are not here with us today, but I'm sure that you will be here, you will be with us at our physical conference probably later this year in Dublin or next year, perhaps in Tokyo. And really looking forward to that. That was such a powerful address. And I think all my colleagues out here from the National Center for Technology and Dispute Resolution, as well as people in the field of online dispute resolution, can see why I term this as an ODR revolution. Because everyone is taking it really seriously. And the true sense of online dispute resolution, of introducing artificial intelligence, data, bringing it to the people, access to justice, leveraging technology, justice as a service, all that is coming to force really soon. Now, I'll hand that over to, I think who's going to be talking next, Deepika or Desh?
Deepika.
I'll be taking over from here.
Okay, so over to Deepika, who has helped, as I introduced her, I think she will now talk about how this framework came into place.
Thank you, Chitu. It's a real pleasure to be here. I'm in fact very humbled to be a part of this gathering. Let me take a second to share my screen. Oops. I hope this is visible.
Yeah, you're good, Deepika.
Yes. So I will take a few minutes to take us through the developments that ultimately culminated in the constitution of the committee itself. This would give us a glimpse of why we are even considering ODR in India and what were the various issues that were before the committee while it kickstarted its work. I think the figures on the screen are eye-popping and self-explanatory. Whoever is following the status of Indian judiciary will know the kind of backlog that it is burdened with. At the moment, across all 3 tiers of Indian judiciary, there are around 43 million cases pending. While that is a picture on one side of the equation, on the other side, we see that India is ranked 163rd in the overall enforcing of contracts indicator in World Bank's EODB rankings. So what we really see here is that on the one side, we really need to take measures to reduce the supply of cases into court system. At the same time, we need an avenue to effectively and efficiently resolve lakhs of disputes that arise on a yearly basis, especially those concerning businesses, essentially contractual disputes. Over the course of last couple of decades, quite a few solutions have been explored, including the ones within alternative dispute resolution framework. However, they haven't been very successful in catering to these twin requirements, which is reducing the supply of cases to courts and second, providing an avenue for effective resolution. And this is where ODR comes into picture as something that can augment the efforts that are already taking place through ADR or through tribunals, etc., as well as enhance opportunities otherwise through, further integration of technology. And here we, world is our oyster in terms of, what we can think about through smart resolution of disputes, automated resolution of disputes, smart negotiation tools, etc. So overall, given the status quo that is currently in place in India, we think that ODR could possibly be a way out of this messy situation we find ourselves in. So ODR is not something that we are grappling with only in recent times. We have Chitu with us, who is known as the mother of ODR, and she is from India. So it is not an entirely new topic for us. And this slide before us tells us how we have been sort of exploring the concept of ODR since early 2000s. 2006, we had a platform to resolve just the domain name disputes, but beyond that, it did not progress much. Then in 2011, a city in India, Chennai, we hosted the 10th Annual International Forum on ODR, and Chitu steered that entire event. While it did create some buzz, there was no large-scale adoption. And then you will see that there have been certain events dispersed over the course of last decade or so. But the real attention towards ODR started only over the course of last 3 to 4 years. And this we can see in the pileup of events in the last part of this slide, which is from early 2019 until 2020, there have been a lot of hectic activity in this entire ecosystem. This also has a lot to do with how overall the judicial system in India has been portrayed to be incapable of bearing the burden of a high supply of cases. So it was almost like the urgency of matters leading towards the entire ecosystem shifting its attention to ODR. And we see that happening through these back-to-back events. In fact, in February 2019, there was an EADR challenge which garnered a lot of attention. And since then, we see a lot of activity in the private sector, especially with multiple startups catering to wide variety of disputes. And then in February 2020, we see that the government of India itself launched an ODR scheme for resolution of tax disputes. And most hearteningly, in 2020, as you can see this as a response to the COVID-19 situation, the judiciary started embracing ODR, and that was a big momentum towards ODR, because once we have judiciary's vote of trust towards the mechanism of ODR and ODR outcomes, it enables the entire ecosystem to move towards ODR with greater confidence. So over the course of last 3 years, what we see is that the government is supporting ODR, the private ecosystem has started providing ODR services, and lastly, the judiciary has come on board in full effect. And this is the trend we see in India at the moment. And this is based on our study of what has happened across different jurisdictions, is similar to what is happening there. That we have certain government-run ODR initiatives, we have court-annexed ODR initiatives, and then we have private ODR platforms. I will take a couple of moments to give you a glimpse of certain initiatives under each of these three categories, and then go on to identification of issues that arose through these recent developments, which ultimately led to the constitution of committee to address those issues. Because without such specific targeted group coming together to brainstorm and think about ODR, the issues would have remained as they are, and that would have proved to be a huge roadblock for widespread adoption of ODR in the country. So a couple of examples of government-run ODR initiatives. We have a portal which has been developed by the Department of Medium, Small Scale and Micro Enterprises. It's a portal that can be used by businesses to reach out to officials who have been designated as mediators. And these are officials within the department as well as those that have been onboarded as an external neutrals who have been onboarded onto the platform. And businesses have been resolving disputes through this Samadhan portal developed by the government. The second is the integrated consumer grievance redressal mechanism. This is a recent development basis certain amendments that were brought about to the consumer protection framework in the country. So at the moment, not only are we seeing developments in terms of mandatory mediation or pre-litigation mediation for certain categories of cases, and that category does include consumer disputes, we are also parallelly seeing a push towards integration of technology while providing those mediation services. And this is part of government-run initiatives. The second is court-annexed ODR centers. Here we are talking about mediation and arbitration centers that are attached to courts who with integration of technology are moving towards providing ODR services. This again, the two items that I've listed over here are developments that happened during the course of the lockdown period. So clearly there was no other avenue to provide justice but to go the technology route. So the first is the online mediation project, which was attached to the Delhi High Court. Samadhan, so Samadhan, as you can see, is a very popular phrase. It translates to resolution. So Samadhan online mediation project was initiated by Delhi High Court to offer e-mediation services. Then the biggest development in terms of number is what happened during e-Lok Adalats. So Lok Adalat is a form of alternative dispute resolution mechanism provided for in the Indian legal framework, which is run by courts. So the courts themselves identify a large category of disputes that can be resolved through mediation. And e-Lok Adalat is a subset of it, in the sense that these are Lok Adalats that were conducted entirely online through a technology platform. And through this, lakhs of disputes were resolved, not just in urban areas, but also in rural areas and tier 2, tier 3 cities, where typically the challenge of digital penetration exists. So with e-Lok Adalats, proof of concept of large-scale ODR was presented for the Indian ecosystem. The last is the private ODR service providers. As I told you, over the course of last 2 years, we have seen more than a dozen odd startups beginning to offer ODR services. We see broadly two trends emerging here. These startups either provide end-to-end services or provide standalone technology platforms. And they have been providing arbitration, mediation, and smart negotiation services at the moment. So we are seeing typically the first phase of ODR kickstart in India. And at least to my knowledge, we haven't gone to the second phase or the more advanced phase where we are talking about automated dispute resolutions, intelligent dispute support systems, etc. And the fourth point, which is important, is the categories of disputes that are being resolved currently through these private service providers. We are looking at banking sector disputes, consumer disputes, commercial contracts overall, and family disputes are beginning to be streamed directly through the ODR platforms and are actually getting avoided from getting stuck in courts. So through these various developments and during our course, during our interactions with all three categories of ODR service providers, we were able to identify that there were a lot of roadblocks that needed to be overcome for ODR to be truly mainstreamed across various dispute categories and to become a first resort for resolution of disputes. The first bucket here is a few structural challenges that are sort of typical to what India as a country is. So there is a huge digital divide. In urban India, you will see, internet being used by everyone and access to digital infrastructure being quite robust. But if you look at rural India, it is still lagging behind over there. So that is a huge challenge that we need to consider when we talk of, mainstreaming ODR in India. Then there is a problem of digital literacy across a huge section of our population. Then we have divide in access to technology. And of course, Indian laws themselves are sort of stuck with archaic legal processes that will need to be changed to truly benefit from integration of technology into dispute resolution processes. Next, we identified a few behavioral challenges because anything to do with technology in India and elsewhere is met with a lot of resistance and a lot of mistrust. So how do we overcome this barrier to ensure that ODR is adopted at a large scale? Second is the legal culture. So here we do have the culture of going to court as a first resort, and typically lawyers themselves are very skeptical of anything outside of the judicial system. So the challenge was about onboarding lawyers as adopters of ODR and as people who will popularize ODR amongst disputing parties. The third is ODR for government disputes. And this again is a very typical Indian problem because we have government as the biggest litigator in the country. A conservative estimate shows that around 46% of disputes pending in the country have government as a party in various shape and form. So how do we enable government to adopt ODR, which will essentially solve at least one side of the problem, which is clogging of Indian courts. And the third bucket of concerns is regarding the concerns of end users, which is extremely important to build trust in ODR and ensure that it is something that is voluntarily adopted and not something because a policy or a law mandates it. And these are the concerns that I heard speakers yesterday talk about extensively. So I'll just list it out. Privacy and confidentiality of data, transparency and accountability of ODR service providers, especially the private sector providers, availability of neutrals. For example, if we do mandate ODR, if ODR becomes the first resort, how do we ensure that neutrals, quality neutrals are available to provide those services? And fourth is enforcement of ODR outcomes, which is a huge challenge. It is an actual roadblock as well as a mental block for anyone who is attempting something outside of the court system. So these were the overall set of challenges that were before the committee to try and overcome through extensive consultations and through research. And that is what the committee took on when it started its work in July 2020. With this, I'll hand it over to Desh to go into the details of committee's work.
Thanks, Ritika. I think you made my life very, very easy. So with Mr. Khan setting the context and providing a macro outlook to how India approached, or at least Nithyayog on behalf of the government of India approached the ODR policy framework, and with the extent and depth of the work that Deepika and her team had already done entering July 2020, I think it basically became more of a process issue for us and a consultative, inclusive process where we took a lot of the knowledge that already exists and tailored it for the government of India from their perspective and from the perspective of how best it could be rolled out in India in its most expeditious and inclusive manner. So I'll just quickly share my screen. And is this visible?
Yes,
Yeah.
Desh.
Okay. So what I'll do is I'll start immediately with the composition of the committee. The committee, as Deepika mentioned, was constituted in July 2020 on the back of what had been several productive conversations that we had had with members of the judiciary, both current and former, as well as industry stakeholders. We got a good sense of the repository of startups in the ecosystem, as well as all the policy work that had been done. So July 2020 was a good time for us to take the next step from the Nithyayog's perspective. So the committee was set up with a retired Supreme Court judge, Justice A.K. Sikri, who is who's known to be one of the most progressive and technology savvy former Supreme Court judges. He was the chairperson of this committee. The CEO Nithyayog, whom you all heard a short while back, was a member of this committee. And then we took 6 of the most critical ministries and took their most senior bureaucrats, basically the secretary level representative from each of these ministries. And so the Ministry of Micro, Small and Medium Enterprises, the Department of Legal Affairs, the Department of Justice, the Department of Consumer Affairs, the example which Deepika in fact had just given in her presentation, the Department of Promotion of Industry and Internal Trade, and the Ministry of Corporate Affairs. These were the 6 secretaries who were representative of this committee. It was convened out of Nithyayog, and the administrative secretariat was in fact established to provide both research and drafting assistance. And this is a gross understatement, because I think a lot of the fluidity, a lot of the efficiency with which we could get a report that actually took into account several of the global leading practices, it was done because we had a lot of the work being done in real time by Deepika and her team. The team consisted of Deepika, who you've just heard, and her team with Vedahi Mishra and Aditya Ranjan. and Satvik Mishra, who's from Nithyayog. The terms of reference of this committee, so our overarching objective was to develop an action plan for ODR in India. The specific objectives started with identifying and amending the existing laws/regulations as well as rules to help enable ODR, an identification and facilitation of strategies to adopt ODR as a means of dispute resolution in the key and relevant sectors, analysis of the global best practices in ODR, specifically for dispute avoidance, containment, as well as resolution to help recommend suitable models for justice delivery in the Indian context. And lastly, and this was in fact what we feel is the most critical component, was collaborating with the judiciary industry and the entire ecosystem to help ensure that the policy framework we were developing was one which took into account all the concerns, considerations, and opportunities for the entire Indian ecosystem. The consultative process, as Mr. Kant had alluded to and Deepika very briefly mentioned, it was a comprehensive exercise spread out over a period of nearly 3 months, where we sought written comments to curated questionnaires from the entire stakeholder group landscape, as well as the committee members, which was then followed by oral consultation sessions with, again, the stakeholder groups. And we also had a series of one-on-one conversations with leading experts with domain expertise, which was then followed with by consultations after the draft report had been shared in the public domain. So what we did is after we had drafted the first version of the draft report with the support of the committee members and all our initial conversations, we put it out in the public domain for public comments for a period of 2 weeks, where we also at the same time engaged with members of the judiciary and also had high-level conversations with domain experts to further improve and expand on the draft report as it stood. In total, we had 18 consultations that we organized with a total of 6 stakeholder groups and 12, sorry, that's a typo, but should be 12 domain experts. We received 63 detailed written responses, which included representation from dispute resolution professionals, businesses, which have been the key drivers thus far of ODR in India, lawyers, dispute resolution centers, ODR startups. Of Deepika mentioned that there were a dozen. I think by the time from the time we started to the time we closed the drafting of the report, I think that number had gone up to approximately 19. Deepika will correct me if I'm wrong. And also what we did was, because last mile access to justice was so critical, we also included the rural ADR service providers. In total, we consulted approximately 85 people with certain repeat conversations that we've had in the last month as well. So taking that number up to approximately 100 in total. We had also engaged with a civil society called Civis, which further extended its outreach to all of the relevant sectors. And they then collated responses from 41 entities and individuals. Meanwhile, and this was a very, very important aspect for us, we had 2 extensive consultations with domain experts from India and especially with Icodr. So Colin, Chitu, Janet, Leah, and Ethan, we had a couple of long conversations with them, and that really helped set the context for us. And lastly, in addition to what we had done with our outreach, we also received 16 representations from several of the stakeholder community at my email address, and we took these into account as well when we were framing the report towards finalization. The report, given the sensitivity of some components of it, as well as with an approach to ensure that it had the maximum benefit to all the individuals who could potentially utilize and roll out ODR. We're in the process of finalizing the report, hopefully in the next couple of weeks. But what we're trying to do is, in part A, which is going to be a report that will eventually be in the public domain, we would provide an introduction to ODR, a background to the committee and how we went about the entire process. We're providing a cross-jurisdiction analysis, a present status of ODR in India, as Deepika had in fact walked everyone through just now, the challenges which are quite key, and the recommendations which I will just shortly walk you through very quickly. Part B, in fact, is where we looked to provide curated approach notes for each of the committee members and their respective departments or ministries, which would in fact lay out an action plan for ODR integration. Deepika had mentioned a very key statistic, which is that 46% of most litigations are or emanate from the government. So with using the government as a lighthouse sector for integration and rollout of ODR, and with the support that all of the departments and ministries were giving to ODR, we felt that this is a very, very efficient way of pointing out what the opportunities are for their particular departments or ministries to integrate ODR. Recommendations very briefly. So I know Deepika had mentioned the challenges, so I'll just quickly go through the recommendations. The increase in access to digital infrastructure was one of the primary components, where we have suggested an increase in physical access to digital infrastructure, along with that of digital literacy. The strengthening of existing and an increase in overall capacity, given that if ODR does roll out to the scale that we are envisioning it to, we would need a significantly expanded capacity base. So the upskilling and training of new professionals with uniform training standards was a critical aspect, along with the strengthening of the paralegal services within the relevant communities. The adoption of ODR platforms for specific government sectors, which again goes back to the government taking the lead. And also the strengthening of the court-annexed ADR centers, which could then harness the potential of artificial intelligence and machine learning. And lastly, with the fast growing private sector capacity and an increasing number of neutrals available to be able to staff a lot of the matters, the resolution of COVID-19 induced disputes is a point of first contact in our opinion. Building trust in ODR with an ongoing awareness rollout plan as well is something that the committee and Nithyayog are looking at very closely. So we have mentioned that ODR for the reduction of government litigation is a key aspect. At the same time, the running of a large-scale, comprehensive and coordinated awareness campaign of the benefits and efficacy of using ODR is something that we are looking at very closely, as well as the introduction of targeted incentives per stakeholder. The strengthening of the existing legislative framework, this is an ongoing aspect with the Mediation Act in the works, as well as introducing a regulatory framework for both mediation and data protection, along with the introduction of certain necessary amendments to key statutes in India. At the same time, we're looking at progressively mandating pre-litigation mediation for classes of cases. And this is where the collaboration with the judiciary is extremely important, and it has been extremely well received by the judiciary as well. So this is a very encouraging sign and shows us what the potential is of ODR from a court-annexed or pre-litigation mechanism framework. The digitizing of legal processes like stamping and notarization is another aspect that we have addressed in our report. And this was again based on extensive consultations with lawyers and dispute resolution professionals. From a regulation aspect, what we are looking to do is recommend a light touch approach, where we are working on voluntary principles for ODR platforms, ODR centers, and ODR neutral / mediators, and also to identify and introduce a SRO, or a self-regulatory organization, which will be composed of members from the ecosystem across the board, basically the entire life cycle of matters. They should be adequately represented within this SRO to ensure that the compliance of principles is established, maintained, and the credibility of the process is also ensured. And lastly, among the several ODR initiatives that we have recommended, the implementation should also be such that it is accomplished in a phased manner, so that it's sustainable and well thought out. So broadly, that was our approach, and also that's how we tackled not only the consultative process, but the drafting of the report and with the criticality of getting a representative, recommendatory. So in terms of, we were not insular enough to think that we don't require the support of what is happening across the world. And we wanted to ensure that no member of the entire ecosystem was left out when we were consulting with them. So that's why we're quite confident that this report will take into consideration a lot of what we hope will be the future of ODR, or as Chittu said, the ODR revolution in India. And of course, I'll finish by once again pointing out that the extensive nature of the work that Deepika and her team had done really helped give us a holistic perspective on what the global best practices were and made our lives a lot easier. So Deepika, good platform to thank you. So thank you. And if there are any questions, please, we'd be happy to answer those.
Yes, unfortunately, it looks like we might have lost Chittu, but I wanted to just say on her behalf, because I know she would say this as well, what an incredibly inspiring and impressive presentation from Deepika and Desh. It's amazing what is happening in India. I think this is the most sophisticated, well-conducted dispute system, online dispute resolution, dispute systems design exercise that's ever occurred. And I don't want to speak for everyone in the global ODR field, but it's humbling to see how seriously and the thoroughness with which this task has been undertaken in India. So thank you so much for sharing. And the world is watching. Not to put any more pressure on you than you might feel now. But let me just open it up for a minute or two and see, does anyone have any questions that they'd like to ask Desh or Deepika about everything that's going on in India? Please feel free to raise your hand or put something in the chat. Desh, I think it's very clear you've astounded everyone. They're stunned into silence by the scale.
Maybe,
please,
Colin,
Lorna.
maybe one question: is there an expected time frame, or is that still premature to think of when we'll actually see?
So the report itself is just going through the final approval processes. So we're not anticipating a period, and Deepika will bear with me when I say this, because we were ready for the rollout a couple of months ago, but what was important is that we made sure that the judiciary was also, and the e-courts committee was also on board with our suggestions. And Deepika, we're donning both hats, could understand where we had to make sure that we were taking everybody along. But our anticipation is that it shouldn't take more than a month or month and a half. Having said that, I don't want to jinx it, but sooner rather than later.
So Colin, this is Jaya Sharma, may I ask a question?
Please, Jaya.
So to my Indian colleagues, I know that in India, you don't have a special act that permits mediation. It's the 1996 Conciliation Act that allows mediations to be undertaken within the framework of an arbitral proceeding. So what I'd like to know is, if you do ODR on a large scale, would you have to bring about any kind of legislative changes to incorporate this into the Indian framework, legislative framework?
Go ahead, Deepika.
That's actually a great question, Jaya, and that is one of the key concerns that we have tried to address in the report as well. So there are two aspects to it. One is the existing legal framework and whether that provides for ODR. The answer is yes. The problem, however, is that this provision for ODR is scattered across different legislations. As you rightly said, there is one legislation for arbitration and conciliation. We do not have a parent legislation for mediation yet. However, mediation is recognized as a part of conciliation, and it is also specifically recognized under the Civil Procedure Code, which governs all civil disputes in the country. So while there is recognition for all kinds of ADR mechanisms across different legislations in the country, we do not have a parent legislation for ADR and no parent legislation for mediation. So what we do suggest in the report is that we first amend the existing legislations. In the first phase, amend the legislations to specifically provide for technology integration into these ADR mechanisms. And in the second phase, which is likely to take more time, we provide for specific umbrella legislation for ODR. So that is how the report deals with it. But as things currently stand, there is no problem to undertake ODR processes in the country. It is perfectly legal.
So I think we have time for one last question. Mayur, I see your hands up.
Thank you very much. Interesting presentation. As you know, the Mediation Center has a contract with the LA Superior Court, which has about 80,000 cases a year that's filed. And it does have one of the largest integrated systems. There's about 650 courts, 550 judges, and we have a contract to do ODR. In fact, we got it in 2018, long before COVID was even thought of. And by foresight and forethinking, we've been using ODR, Zoom conferencing, since 2018. And we did get a contract, which is very extensive. And what the court decided to do was to outsource all mediation services. It used to run a program which was quite extensive with over 10,000 cases a year, but it changed that because of the budget cuts. So when it outsourced the program, the ODR program, we basically, they put all the burden, the financial burden, on the private sector to operate and run it. So we've been operating as a nonprofit. We're the only nonprofit that has a contract with the court. The other two are proprietary. I just give you that background because my big question is how in India, who pays for the services of the private industry panels? Because in our case, they've left it to us to raise the money to provide either low cost or free mediations, and they've left it to us to charge the parties some small fee to access the quality mediator. Also, we have very high standards that the court imposed on us for our mediators, and it was up to us as private panels to vet all these standards, which was at least 10 years of good standing, 20 to 30 years of practice in the law, and at least 40 hours in warden training and experience. So we have very high standards, but all of that was outsourced by the court to the private panels. I'm just curious, who pays for everything in India?
Great question. Desh, Deepika, who's going to foot the bill?
So that's a tricky, situation. In India, we haven't actually progressed so far as to actually identify who is going to pay the bills, who is going to fund this entire initiative. From our experience with the arbitration sector, what we've seen is a lot of private arbitration centers are functional. At the same time, there is a cap on arbitration fees, arbitrator fees provided for in the legislation. So that we know is proving to be problematic for the sector to thrive and to attract quality professionals. So arbitration bar is not yet a thing in India. To avoid similar, as in I can't say for sure which direction mediation will take, because as I said, we do not have an umbrella mediation legislation yet. So we will have to wait and watch if mediation legislation will also similarly prescribe a schedule for mediator fees. But we don't yet have clarity on that. The way it is currently structured, we have mediation centers attached to courts, which have very nominal fee. but that is applicable only for disputing parties who do refer their matters to these court annexed centers. The private mediation centers continue to exist, and there is no bar on the fees that can be charged. Wonderful.
Well, I would like to wrap it up there. I think we could easily talk about this for the rest of the day, but I think I want Deepika and Desh to hear from all of us in the global ODR community. We want to continue to be a resource. We're very excited about the work that you're doing. And if maybe all of us could join together and give a round of applause to our panelists for an excellent keynote presentation this morning.
Thank you. Pleasure to be here.
Yeah,
thank you so much. Please, Chitu.
It is really great to hear, I think, for the global community on what India is doing. And I think look out for more. We are going to have a page dedicated on Icodr just for India. You could see all the updates on what is happening with Nithyayog. The draft policy will be out there. The articles about what's happening in India is out there. We will also put up, what's happening with the Reserve Bank of India. We're having an ODR handbook, which is coming out. That is also going to be up there. So please look out. Lots of things coming out from India. Thank you, everyone. Thanks so much, Tej. Thanks, Deepika. Thanks a lot to Mr. Kant for sending us that video recording, and hoping that, we will all meet soon. Thank you.
And thank you as well to Chitu, the mother of ODR in India, for planting these seeds that are now growing into a forest. So wonderful, wonderful. What an excellent session. Okay, let's turn now to our good friend, Dave Larson. Dave, maybe you can take the reins and take us into our next session.
Okay, thank you. I'm going to try and pull up a screen here in a minute.
And Dave, take your full time. We're moving into a break, so we have lots of flex. So please take all the time you need. Looks great, Dave. We can see your slide.
Perfect. Okay, so good morning for some of us. I'm going to be talking about ODR accessibility for persons with disabilities. I believe we can and must do better. It's such an exciting conference. There's so many things we can talk about. These are topics in this first slide that I think are themes throughout the conference. It's such a wonderful opportunity to reimagine justice. Do we really need cross-examinations in every case? Do we really need physical courthouses with 40 steps going up to the courthouse that many people can't climb? We need to think really broadly about not just the processes, but the delivery mechanisms for justice. And we could talk about that for a long time. Apples and oranges, digital divide versus access to justice divide. I think that, for me, I think the digital divide is smaller than the access to justice divide. I think the access to justice divide right now is massive. As some of you know, I worked on a project for New York credit card debt collection cases. The situation in New York was that for people that were served in credit card debt collection cases, 92% were having default judgments entered against them. They were not engaged with the justice system at all. When you think about the amount of remodeling and adjustment that has to be made in physical courthouses to make them accessible, it's just my feeling that our current access to justice divide is massive. Not to say that there isn't a very real digital divide, but I think that it's more easily addressed. And that's a relative term because it isn't easily addressed, but it's more easily addressed than our current access to justice divide, which means that's very promising to point our attention to ODR. E-commerce is not the same as public law. I think as we go through the 2 days, we should be thinking about that. And then more on point for what I'm going to be talking about, I think accessibility is a universal issue. Accessibility, usability, when you're talking about access for persons with disability, we tend to use accessibility. There'll be another presentation today about usability, but I think that's our ultimate goal, is usability for everybody. Serious questions. What technology are you going to use? Are you going to create your own? Are you going to adopt someone else's platform? You adopt someone else's platform, you're going to have to understand that it's going to come with some inherent limitations. They're not going to be able to do everything you want to do because they have their own internal restrictions, and they'll work with you as much as possible. But you're going to have to make some adaptations to what they have prepared. You want to create your own system? Well, that's great. You can really tailor it to your needs, make it as accessible as you want to make it. But you're going to have to spend some money to do it. You're going to have to not just build that system, you're going to have to maintain it. You're going to have to update it. These are all serious, significant questions. And you also, right from the outset, have to ask that question: what are going to be your standards? What are going to be your ethical principles? Put a little plug in here. I know it's come up before now, but the Icodr.org standards, I think, are a great place to start. There are the standards. The intention was make them as succinct and understandable as possible. There's a little narrative that goes with each of those standards, and the PowerPoint has a hyperlink. And throughout my PowerPoint, there's going to be hyperlinks, and the PowerPoint's going to be available so people will be able to click on these things. But I encourage you to look at those standards if you haven't already, and to think about them, and also think about how you might want to supplement or amend those. We're working on a project now. I'm co-chair of the ABA ODR Standards Task Force. Linda Seeley talked about this a little bit yesterday. We're trying to look at all the existing standards that we can find and put together some standards on behalf of the American Bar Association. If you're a foreign lawyer, international lawyer, FYI, you can join our section for $150. We would love to have your perspective. I hope you will consider it. It's all hands on deck. We're moving forward very quickly with online dispute resolution. We can use every hand we can get. Obviously, technology is not a panacea. It's not going to resolve all our problems with accessibility. I'm going to be talking about that today. I think we should avoid conceptually segregating persons with disabilities as a general rule, although I'm going to be talking about them today. But accessibility is a universal issue. All online activity should be accessible for everyone, websites and apps. I'm going to talk a little bit about the legislation that's out there and whether or not that's accomplishing what we're hoping it's going to accomplish. I'm going to talk a little bit about best practices. You know, what is ODR? Why do we even need to know? Well, if we're going to have standards, it's just really helpful to know for what process or practice you're developing standards. Resolution Systems Institute would say it's a broad set of technologies that supplement or replace ways in which people have traditionally resolved disputes. That sounds like Zoom. But what about the communication technologies, algorithms, blind bidding, artificial intelligence that we've now been talking about for almost a day and a half? I like the National Center for State Courts definition of what is ODR. I put a little brackets in there for private ODR. So they wrote one, actually. Obviously, the National Center for State Courts, so their definition relates to court-related practice. But if you look at my brackets, you can plug in a private mediator. So we got court-related ODR as a public-facing, and if you're a private mediator, you would say private-facing digital space in which parties convene or resolve a dispute or case. Okay, that could be Zoom. Operates exclusively online. Well, do you operate exclusively online when you're using Zoom? Do you use a telephone? Do you still use mail? Was the process explicitly designed to assist litigants in resolving disputes rather than only support judicial or court staff decision-making? Well, now I don't think it's so. It wasn't explicitly designed to assist litigants in resolving disputes. And now I think we're starting to see that divergence between communication technologies and ODR. And then the last part of that definition, it integrates and extends dispute resolution services offered by the judicial branch or you, the private mediator, into a digital space efficiently, effectively, transparently, and fairly. Should ODR be a term of art? I tried to make a term of art. to narrow it down about 10 years ago, maybe 15 years ago, actually. I threw out technology-mediated dispute resolution. I wish I'd used technology-assisted dispute resolution. I like that better. Some people picked it up, but it never really caught traction. But again, I think it's important to know what we're talking about when we use ODR if we're going to be writing standards and principles for it. But regardless of whether what you're doing is what we would say is ODR, we're using more and more technology, and that means we've got to think about how we're doing it. It's great potential, but it has significant implications. Can ODR improve access to justice? Yeah, I think it can. I think that, in my mind, that train has left the station. Parties can't always appear in court, and they don't. And New York's a perfect example of that when it comes to credit card debt collection cases. People are ashamed, they're afraid, they don't have any vacation time, transportation issues, childcare. Maybe they're afraid, physically intimidated by the other party, maybe because of disability. They find it difficult to move, they have a mobility impairment. I think absolutely that ODR can improve access to justice, but we have to be careful because not always. Jim Coven wrote an article in a journal I created called the Journal of Alternative Dispute Resolution and Employment that I ran for about 4 years in the late 1990s to early 2000s, where he talked about mediators' dirty little secret and talked about the ways in which mediators can influence dispute resolution proceedings and all kinds of like timing and reframing. I think right now that danger is even greater because when we think about neutrals, neutrals right now have an enhanced authority. They're not only the dispute resolution process experts, that they're going to be your tech expert. And right now, best practices of, at least what I hear in the American Bar Association, is people ask disputants to get together and talk about the platform and become familiar with the platform, become familiar with the technology. So what does that do? Well, what that does is that positions the neutral as the expert, the person with the answers from day one, from the first minute. And so we work through the technology. I answer all your questions. And now we're going to step back. And now I'm going to turn the dispute over to you. And I'm just going to be a facilitator. But you think I'm now the expert because I've been the expert. And I think that in a very subtle way presents some problems for online dispute resolution and our online neutrals. And I think we need to be aware of that somehow you've got to reposition yourself, that if you've assisted people with the technology, you've got to step back and say, we're moving to a different stage now. And the process is in your control, and I'm not going to give you all the answers. The potential, if you want to control it, is exponentially greater than it used to be. You could do all kinds of things, alter form and voice and pitch and timbre. If it's an asynchronous proceeding and you actually have communications in your hands before you relay them to the other party, you can go crazy if you want to. You can do all kinds of things. So we have to be very careful, and we want to have standards to make sure that people are not using the technology in ways that are going to influence the proceedings in ways that we don't think are desirable. Are you accessible in what you're doing online? Again, going back to where I started a second ago, to the degree that you are assisting someone with a disability to become familiar with the technology, have now you become their guide, become their unspoken counsel in this next proceeding? And can you step back from that? And how are you going to step back from that? I think there's going to have to be a lot of repositioning now with online dispute resolution. I don't think we're ever going back. COVID-19 has accelerated adoption of technology. USA deaths, and now we're 500,000. More people have died than in World War I, World War II, and the Vietnam War combined. It's just stunning. I think some services may never be offered again face-to-face. And I think that because of that, there's a very real danger that vulnerable populations, including persons with disabilities, are being excluded from all kinds of aspects of our new normal digital world. A lot of pressure on courts, agencies, businesses, practitioners. Let's build our online services as soon as possible. We want to make sure, however, that we're designing them so they're accessible with persons with disabilities. You know, we built our physical structures well before the Americans with Disabilities Act. Now we're having to go back and tear those things apart. A lot of money, a lot of expense, a lot of redesign. It's not easy to redesign and rebuild structures, and online dispute resolution processes are structures. We should be building them accessibly rather than thinking that I want to get it up as soon as possible and I can go back and fix it later, which I think is happening in a lot of instances. People are saying, I got to get up there, I got to have a presence, but then they're not thinking very much about all the accessibility issues. Who should we be concerned about? Many of us have disabilities. I got to believe that everybody here either has a disability or knows somebody with a disability. Center for Disease Control says that 1 in 4 Americans have disabilities. CDC doctor says that most people will have or know someone with a disability. That sounds right to me. You know, but again, as we're thinking about ODR, we don't want to just limit our accessibility issues to disability. We've got other issues to think about. We've got broadband issues and access. We've got financial issues, hardware accessibility issues. So we do want to think about usability. Why should we be concerned? Well, the numbers are discouraging. The Information Technology and Innovation Foundation in April last year assessed the accessibility of state government unemployment websites, and they did it by comparing it to the Web Content Accessibility Guidelines, which are probably the most comprehensive guidelines, giving you instructions about how to make certain that what you're doing online is accessible. We're in a pandemic. I mean, we have Great Depression levels of unemployment. If unemployment websites are not available, that can be catastrophic for people. And what they found in April 2020 was that 39% of unemployment websites failed accessibility test. So you're talking about people that, you know, struggle to find employment anyway. If they're lucky enough to find employment, the unemployment numbers for persons with disabilities are they're very low compared to other identifiable classes. And to the degree they could find employment and they've lost it, and now they've got to try and find support and employment through the state agencies. The idea that you can't even access those state agencies to get the money that you desperately need right now is really, I think it's really frightening. That same foundation reported back in about a year and a half ago that 41% of 400 state government websites had problems that could prevent access for persons with disabilities. So those numbers are about the same. That tells me in a year and a half that we haven't seen a lot of improvement in terms of accessibility. A lot of research groups have looked at this. Nucleus Research reported a digital divide for blind persons. The Global Initiative for Inclusive ICTs looked at hundreds of e-commerce news and information government websites, found that 70% are inaccessible to visually impaired users. In January 2020, I think this was a really interesting study, and I have the hyperlink to it. I encourage you to go look at this study. They did a survey of 29 countries. They got 76 respondents. Most of the highest responding group were people affiliated with the court, the judges, the prosecutors, the advocates, but another relatively high percentage, about 12%, were professors. Any empirical study, you always want to go back and kind of look to see who did it, how it was assembled, what kind of coverage, what kind of input did you get. But thinking with a really broad brush, at least as a starting point, looks like I have pretty good global coverage in terms of the survey they were doing about the accessibility in their own court systems. But again, some discouraging numbers. Less than 10% of the courts had specific budget allocations for ICT accessibility and digital exclusion of persons with disabilities. 48% of courts do not or only partially meet accommodation requests for persons with disabilities. Not surprising that the obstacles are insufficient financial resources, lack of awareness about disability, lack of knowledge about accessible technologies. Approximately 40% of courts provide technologies solutions for digital inclusion of persons with disabilities, but that compares with almost twice as much effort being made to ensure physical accessibility. So again, this whole idea that we got to make our digital activity as accessible as we're making our physical activity, it just hasn't landed yet. We're not there. 38% of courts report having a low or very low level of accessibility and inclusiveness of the technology deployment for persons with disabilities. Why should you do it? Well, I think there's lots of good reasons to do it. It's just good business. You get a larger audience, you get more customers, you improve the lives of persons with disabilities, and it's becoming more of a reality. You're going to avoid lawsuits and you're going to avoid bad press. I'll talk a little bit about each of those. Universal usability, accessibility, you bring persons with disabilities into your audience and customer base, but it helps a lot of other people. If you're in a noisy environment and you've got video with captions, anybody in that environment is going to appreciate those captions. If you've got limited bandwidth that can't pick up a lot of graphic images, somebody with limited bandwidth will appreciate a clean, well-designed, easy to follow, easy to see, uncluttered website. Accessibility is a human right. The United Nations Convention on the Rights of Persons with Disabilities, the CRPD, recognizes that persons with disabilities are going to be excluded not only from effective dispute resolution and court systems, but from life in general in our new normal rule. Article 9 of that convention says that we need to promote access for persons with disabilities to new information and communication technologies and systems, including the internet. Well, that's going to include online dispute resolution. Article 13 ensures access to justice for persons with disabilities. Access to justice for persons with disabilities is an internationally recognized human right. Do you really need to worry about liability? You know, I know the most about the United States, and so I'm going to talk mostly about that. I will talk about some other foreign legislation, but here's the definition. And as you see these things, I'd like you to reflect on how your country or location is defining disability. But we're talking about a physical or mental, in the United States, a physical or mental impairment that substantially limits one or more major life activities, or you have a record of that, or you're being regarded as having that. So either you have it, you have a record of that, and someone's relying on that record to discriminate against you, or you might not have any disability, but somebody thinks you do, and they're discriminating against you based upon that perception. Lots of different titles. Title I of the Americans with Disability Act deals with employment. Title II, state and local governments. For state and local governments, our United States Department of Justice has provided technical assistance and guidance. State and local governments have a duty to ensure persons with disabilities can participate in all programs, activities, and services. Title III deals with public accommodations and commercial facilities. And service providers, that's where your online dispute resolvers are going to be picked up as in Title III. Your services have to be accessible, but only where readily achievable without much difficulty or expense. So the obligations under Title III, I would say, is probably a little lighter than they are under Title II for the state and local governments. State and local governments are going to be picking up the court systems, however. Just kind of a general statement. In the United States, when we're thinking about disability, and your country location may be different, but after bouncing back and forth on the Supreme Court saying, do consider mitigating measures, Congress stepped in and said, amended the Americans with Disabilities Act and said, when we're deciding whether somebody has a disability, don't take into account mitigating measures and making that assessment. If somebody's diabetic, don't decide whether they have a disability after they've taken their insulin. Decide how bad their diabetes is before they take their insulin. Don't decide if someone has a disability after you've attached their prosthetic arm. Decide before you attach the arm, which I think is important. In particular, looking at that number 4, it may be someone with a disability has learned something behaviorally or has adapted to some neurological condition. They've worked really hard to overcome something. And to punish them by saying, well, congratulations, now you've taken yourself outside of protective legislation, I think is just cruel. I think that when we think about persons with disabilities, we should make the assessment before we take into account any kind of assistive or mitigating device. United States right now, we're not doing great. Title III, when we're talking about access for physical structures, we've done a lot of guidance, but the ADA was written before our lives went online, written in 1990, effective in 1991. Title III, which again deals with public accommodations and commercial facilities. So we're talking about all of our private dispute resolution services. Title III requires reasonable modification unless it would be an undue burden or fundamentally alter the nature of the business. So, okay, public accommodations. Is a website even a public accommodation? 10 years ago, no, it's 11 years ago, the Department of Justice published an advance notice of proposed rulemaking, considering whether to adopt the Web Content Accessibility Guidelines as a website accessibility standard. That was great. That was forward thinking. There was time. Nothing happened. 5 years ago now, actually, as we go in 2021, it's 6 years ago, Department of Justice said it'll pursue separate rulemaking for Title I or for Title II and Title III. And then next year, it just said, we're not going to do Title III. It withdrew its notice of proposed rulemaking. So what does that mean? So when we're thinking about whether there's liability under Title III for what you're doing online, we don't have any Department of Justice rules to tell us what we should do. Websites can, and I believe all should be covered by the ADA. Courts have decided that if a store or some kind of business has a physical location and that physical business has a website, that extension of that physical business into digital space is a public accommodation, and it will be covered by Title III, which means you have some accessibility obligations. But what if you don't have a physical location? What if you're an online dispute resolver who just operates out of your home? You don't rent an office. You don't publicize yourself as having an office. You don't present your home as an office. Well, courts of appeals in the United States are divided whether you need to have a physical location before you're going to be covered by Title III. Some have said, no, you don't. That's where we are right now. Another challenge was, I said the Department of Justice has never issued any guidelines or rules about digital accessibility. So a lawsuit was brought saying, well, if the Department of Justice can't figure it out and can't tell us what obligations we have for accessibility under Title III, well, then I think it's a violation of due process to sue me under Title III. How can you sue me under Title III under such a vague standard that the Department of Justice can't even define it? Well, we finally got a court resolution of that, where the court said, the obligation under ADA is pretty clear. You have to make things accessible. And the fact that it's not spelled out letter to letter is okay, because the whole point of the ADA is give people flexibility in meeting the obligations. So that's the Title III standard. Good luck. So you have to meet Title III, at least if you have a physical location. We know everybody does. And some of you, even without a physical location, have to comply with Title III. But here's what I'm going to tell you. You can be flexible in applying with Title III. Well, that has left us with a lot of confusion, a lot of opportunities for plaintiffs. I had an appointment, GM, General Managerial appointment with the Equal Employment Opportunity Commission headquarters when the ADA was passed. And we did a lot of work and created a lot of substantial guidance for Title I, where I was working, but there's a lot of guidance for Title III. And just as a comparative analysis, there's much less guidance available right now for Title III, for Title III digital activity. All we've got is that standard that you can be flexible in complying with the ADA. Lawsuits are increasing. If you look at the federal lawsuits under Title III, there's a slight dip in 2020, but that's because of COVID-19. A lot of courts were closed and it's difficult to start a lawsuit, but we're going to pick back up in January 2021. 1,108 Title III cases were filed in federal court, the most ever in a single month. So the possibility of liability under Title III is becoming very real and increasing, I think, every day in the United States. Title III, it's not the greatest act for plaintiffs. You can't get monetary damages if you're an individual person with a disability and you want to sue a website. You can get an injunction. You can recover attorney's fees. You can file with the United States Attorney General, get monetary damages, but that means you got to wait for the Attorney General's office to do something. A few states actually give monetary damages. California, it has the Unruh Act that says each offense is 3 times your actual damages, but has a cap of $4,000 plus attorney's fees. So you're not going to recover a lot of money, but you can recover some money. You can recover $4,000 and get the website fixed. So Department of Justice used to be very active getting settlements. They've kind of backed off. When they backed off, that's why we started getting all this litigation. So you can see the ADA settlements. You know, once the Department of Justice stopped getting involved in about 2015, those settlements that the Department of Justice was negotiating went away, and now we're just getting lots of lawsuits. And the lawsuits again are going up. Here's a slide from UsableNet, which I think is one of the good private accessibility services. And one I'd recommend you talking with if you're really interested in accessibility. But they point out that again, the number of ADA accessibility websites is increasing quite quickly. What's happening is because you can't get money damages, but you can't get attorney's fees. So what's happening right now is that people are filing lawsuits, and because the defendant respondent understands that you can't get damages, you can only get attorney's fees, that they don't want the attorney's fees to run up and they don't want to drag it out, so they're paying the settlements really quickly. So you got to demand a letter and say that, oh man, I'm going to be liable for attorney's fees if this goes to litigation, because you know that you're inaccessible. So you're paying very quick settlements. There's a little cottage industry that's grown up of people that are challenging websites, and so many are not accessible that they have good claims. And because the attorney's fees will run up over time, people are settling those demand letters very quickly. The few states that have damages, like California, are the places where most of these cases are being filed. New York and California are seeing the most of these cases. United States, you know, I said they're not doing very much. They did try and pass an Online Accessibility Act. I don't think it was very good. They're going to make it, the requirement was going to be, you have to comply with the Web Content Accessibility Guidelines 2.0. Well, those were passed in 2010. You know, we've had 2.1 since 2018, 2.2 are in progress. So why start with 2.0? The legislation says you can't even file a complaint with Attorney General until 3 months after you give written notice to somebody that their website is inaccessible. That idea that you can't, you got to give notice before you can sue somebody that's breaking the laws, something that I think is very controversial and raises some equal protection questions. Why do these people have to give 90 days notice? So Attorney General can get money damages, but the court said you have to, the legislation said you have to consider good faith efforts to comply. After you go through the Attorney General, there's a private right of action, but you have to plead with particularity each element of plaintiff's claim. Okay, so in the United States, we used to have something called notice pleading. If you want to sue somebody, you just got to give them notice of what you want to sue about. Then we moved to a couple cases, Ashcroft versus Iqbal, that said, that's not enough information for the defendant. You've got to give enough information that plausibly suggests an entitlement to relief. So something a little more than just notifying them of the event that you're suing about, but something that gives the defendant some idea of why you believe they might be liable. But this act would say that, that's not enough. You're going to have to plead with specificity and particularity, each element of plaintiff's claim, which again seems to me a little bit of an equal protection problem, that we're asking persons with disabilities to do more than other plaintiffs. So it's bad. I think it was bad. So I'm happy to report that the act failed, and the 116th Congress didn't pass the legislation. Canada, I'm not going to talk a lot about Canada, but I would like to refer you to the Ontario legislation. It's noteworthy if for no other reason, is because they put it into place all the way back in 2012. And Ontario has been a real leader in terms of internet accessibility. And they continue to move forward. By January 2021, just recently, all internet websites and web content had to conform with 2.0 level AA. In the web content accessibility guidelines, you have different levels, 3 different levels, A, AA, AAA. The idea that they're saying that everybody now, as we sit here today, has to conform with the web content accessibility guidelines is a great thing. European Union, we've got European people here. I'm not going to pretend to be an expert in that. They have directives about disability accessibility. One discouraging thing to me is that compliance is not going to be required until June 28th, 2025. Seems too far off. I don't know why they've pushed it out so far. But again, those are some citations that you'll be able to look at after you get the PowerPoint. National Center for Dispute Resolution. I referenced the Icodr standards are there. There's other information there about ODR providers around the world and about courts that are using ODR. So again, if you're interested in who's using ODR and if you want to see what they're doing in terms of accessibility, it's always good to learn from other people. And here's someplace I encourage you to go. What should you be doing? Well, in kind of general best practices, adopt a disability standard. Web content accessibility guidelines, I think, are the gold standard, and I would point you to looking at those. They're not what I would call an easy read. You might have to have some assistance from a website developer to kind of work their way through, but that if you do that, I think you're going to be very safe in terms, certainly in terms of any kind of liability, but also you're providing a really good service. Comply with ODR principles and standards. I talked about Icodr. Have a digital accessibility coordinator that somebody's watching out for this. And maybe if you're a sole practitioner, that's going to be you, but somebody's got to assume that responsibility. Include accessibility in your technology contracts. Whoever you're buying services from, put in your contract that you expect them to be accessible. Put the obligation on them. In your request for proposals, even before you sign the contracts, put in your request, ask them to be compliant with the web content accessibility guidelines. Train your staff and to maintain your websites. Test your website. WAVE is a free tester. It's not the most comprehensive one, but it's free. It's a good place to start. You can just easily download that and check your own website. It'll pop up things that are not accessible. A really important best practice is use persons with disabilities as testers. Don't just rely on particularly an automated website checker. You really need to use persons with disabilities as checkers to see whether they can use your website. There are website accessibility organizations. There's a long list of them. There's a short list. A long list does exist. And in the book chapter I wrote for the new treatise, I put a lot of those in there. Not all of them use testers. Accessible Web does, Usable Net does. I would encourage people to use a disability accessibility organization that uses actual testers. Put an accessibility information link on every one of your pages. Make accessibility part of your job description and evaluations, and always be evaluating every stage of your process for accessibility. So I'm going to be wrapping up. We're in part having this conference to celebrate the publication of the second edition of Online Dispute Resolution Theory and Practice. I've got a chapter in there that includes much of this material. And again, this website's going to be available for you. So don't hesitate to contact me. There's my contact information. And I talked quickly. I apologize if it was too quickly, but you are going to get the website. You go back over what I said, and thank you.
Dave, thank you. That's a great session. Actually, I'm trading lots of messages back and forth with everybody at mediate.com and arbitrate.com saying, let's try Wave, let's do this. Have we tested this out? Are there plugins for WordPress? So you're inspiring us in real time. Does anyone have any questions or comments for Dave? Please don't hesitate to put your hand up or unmute if you'd like to ask something. Well, you're getting a lot of raves in the chat, Dave.
David, where are you seeing the most significant problems still that are sort of like the avoidable ones where it's like, we should be smarter about this. This is one that after all these years, we should have really gotten, like where, especially in those court spaces where accessibility is really, really key, like where are you seeing the most stupidly avoidable items?
Well, you know, the one thing that was kind of disturbing when you looked at that survey and the budget allocations, the fact that people aren't being proactive in making budget allocations for accessibility issues. People are becoming more aware and are going back and looking at it and reconsidering whether they're accessible, but this more proactive posture is not being assumed very regularly. And that's kind of discouraging. And I think that would help greatly if people began preparing for the accessibility challenges, which sometimes aren't actually that great. The modifications don't have to be that substantial, but just more forward thinking, recognizing that this is an obligation I have, and I'm going to appoint someone with that responsibility. I'm going to give some budget appropriation for that, and you know, I'm not going to wait later till I get sued to try and fix it.
Thanks, Chris. Well, Dave, thank you so much for your presentation. This is great, and I can't wait to read the chapter. Can we please give a round of applause to Dave for his great presentation today?
Thank you. And you can always contact me. I look forward to hearing more from you.
Excellent. All right. Well, thank you so much. Let's take our break. Let's make it slightly constricted if we can. It's 8:52. So if we can take 8 minutes and then come back at 9 Pacific time, which I think would be 12 Eastern, we'll dive right into our next session. So thank you, everyone. Take an 8-minute break and we'll see you back here soon. Okay, are we ready to get going again?
Ready.
Excellent, excellent. Claire, Herb?
Yeah, just a sound check. You can hear me okay, Colin?
I can hear you just fine. I think we're ready to rock and roll. Let's give people a second to re-engage. Have your last sips of caffeine so that you can speed through everything. Hi, everyone. Welcome back from the break. Boy, I'm overwhelmed with how many amazing topics we've had just this morning, and there's much more great stuff to come. So why don't we dive right in, and I'll hand it over to my good friends Claire and Herb, and can I leave it to the two of you to introduce yourselves?
I mean, perfect.
Great.
I think you just did.
Yeah. All right. Well, it was a rhetorical question. So please, Claire, why don't you take it? Okay.
So yeah, my name's Claire, and my big claim to fame is being Colin's good friend. Also, VPmediate.com, and I work on Caseload Manager. So for many of you, that's how I've had the chance to get to know you. And today I get to work with Herb from ICANN, and we're going to be talking about designing online dispute resolution systems. And Jan, if you want to jump in at any point, because this is covering a lot of what was in your material, I'm realizing that would be great. So I'm going to go ahead and share. Okay.
1 second. Moving my Zoom controls out of the way here, which is always fun. There we are. Okay, so here we are, Claire and Herb. Again, I work at Mediate, Herb works at ICANN, and we wanted to come up with a presentation that first talked about the idea of designing. And I wanted to spend a second on that word because I feel like up till now, as we've looked at different dispute resolution options, you kind of take what's there. You know, you looked at the different systems that were available. For instance, I remember 5 years ago, I was so excited by Skype. It was the thing that was there, and it was great and it worked. But let's face it, now we get to be a little bit more intentional, right? Now we actually do get to design what we want. And how amazing is that, that we have reached this point in the growth of online dispute resolution that we get to step back and say, okay, we've spent the last decade or so looking at a lot of different options. Let's take stock of where we are and what has worked and what we can improve on. And so that's why I like this word of designing, because it really is talking about being intentional about what we want. So next, of course, we want to talk about online dispute resolution because that expands our reach. It simply allows us to have a larger impact. And at a place like ICANN, where Herb is working with people literally around the globe every day, then he needs that expanse of a reach. We also wanted to talk about the gathering of information because I think that's one of the neatest parts about online dispute resolution is that as we're gathering that data, then we can use it to look at trends. We can use it to gather information so we can improve our services going forward. We wanted a system that's going to be creating a sustainable process. And finally, how can we be effective? Because let's face it, the one resource that we all have that is the most valuable is our time. So how can we design a system that is capitalizing on what works and we're getting rid of what doesn't work, okay? So that's why we are looking at a system for designing online dispute resolution information systems effectively, or if we're going to shorten that, let's just call it deodorize, all right? So here we are, the new norm. We are now at a place in this world where we're all going in the same direction. So let's take direction from each other about how to improve ODR systems going forward. And this is coming from, of course, Mediate.com's caseload manager, as well as looking at CREC, Modria, Legaler, Practice Panther, MadTrack, if any of you remember that, of course, Clio, and then how ICANN has taken this to design their own dispute resolution system. So if you're wondering where some of this data is coming from, I just wanted to make sure to throw the names in there. Okay, so first, I want to look at what we tried. Because let's face it, perfection does not come overnight. It takes some time. So here are things that we tried, and then we decided let's not do that again. That was a bad idea. First, we were working with a company that created an app on Alexa for relationship disputes. Now, I just want you to pause and think about that for a second. Imagine that you're arguing with your partner in the kitchen, and you say, "Alexa, tell me who's right." And ideally, you have it programmed to say, "Well, you are, Claire, of course." But you know, Alexa didn't do that. And so I realized apps don't really make as much sense for relationship disputes. For other types of disputes, sure, but we decided, okay, we definitely want to have some kind of human involvement for some pieces of the relationship disputes. So then we looked at creating an app for resolving company complaints. And again, realize that there's so much complexity that it's hard to simplify it into an app, okay? So then we thought, let's design a system where we charge per person. And this was specifically at Mediate.com that we were considering this. And then we created this, this dispute resolution system, and we suddenly had 300 people sharing one login, so they only had to pay for one user. And we realized that is probably not the right approach either. Then we created a caseload management system that was fun. It had lots of things, but it just had too many features. And for a lot of people, a dispute resolution system should only be supporting their job. It is not their entire job, right? And so they don't need to spend 8 hours a day trying to figure out how all of the little pieces work. It should be obvious. And so then we realize we need to hide some of these features, obviously. Some of the other things we looked at that, again, we have since abandoned, a really lengthy intake process, which makes sense when you think about it, because when people they're entering personal information online, until that information has been confirmed, they do not want to enter more than just a few fields. So now a more common intake are things like your first and last name, your email, maybe a phone number, but even that's pretty iffy at this point. And then a quick summary of the dispute. Anything beyond that, and people started to get a little angsty, right? They started to say, well, why do you need all this information from me? How do I know that there is really a real person on the other end of this? And then people would bail. So we've abandoned the lengthy intake. Other things we tried was, we tried getting a credit card from people before we ever spoke to them. We realized, well, that doesn't work. Again, people want to know that there's a real person on the other end and not just some kind of a spammer. We also tried getting the credit card at the end when everything was over. We all know that doesn't work, because at that point, people are happy and they're ready to go off and think about something else. So we also tried to design the one perfect system, the one ring that will satisfy them all. And I mean, just think about the complexity of dispute resolution systems that are on this call alone. We have ombuds, we have mediators, we have people from every different type of a practice, right? So there's no way to design one system that works for everyone. There is also not one perfect platform. We all like Zoom now, but it doesn't make sense all of the time. There are times we need things that are more complex. So we want to also be able to integrate with MS Teams or something a little simpler like Join.me, or only do an audio call. Another thing that we have tried was just telling clients, trust us, we have it all figured out. And this obviously doesn't work, because we're trying to build rapport, right? We're trying to let clients know this is a safe process, this is a secure process. And so instead of just saying trust us, we've learned, we actually have to be a lot more transparent than that. Which goes to the next point, not allowing clients to interact or feel involved. Let's face it, we are in a world where people expect to be able to design everything. They expect to be able to run their own divorce. They expect to be able to create their own company. And so their clients need some way to be involved with their own dispute resolution process. Even if that only means uploading documents, or maybe posting a chat somewhere. Maybe being able to see a timeline and having people be transparent about where the dispute is in the process. But something that allows people to feel involved, we've realized, is necessary for them to stay engaged during the process. And a final thing that we realized, if it's a very cumbersome sign-on, then it discriminates against allowing everyone to be involved. So what that means is that if we expect people to have a fancy laptop setup where they can write out a really long description of what's going on, if we expect them to have enough bandwidth to be able to interact for long periods of time, or a safe and quiet place, then without realizing it, we have actually discriminated against some of our clients from allowing them to have full access to justice. So by creating products that are simpler, where it is more of a springboard of an intake process instead of an obstacle, then we are allowing more people access to be able to resolve their disputes. Okay, so those are all the things that we tried, and we realized this doesn't work. So now let's look at what we learned. What we learned was that a really good dispute resolution process can be distilled down to three things. It needs to be simple, it needs to be safe, and it needs to be smart, okay? So a simple process, what that means is that this should not be confusing for our clients. It needs to just be crisp and clean. I'll give you some examples in a moment. Safe, to clients, they need to feel safe. For us, we know that that means data security. We know that we're protecting all the different parts of the process for them. And then finally, it needs to be smart. We need to create a system that is going to react and learn and grow or shrink with a company. Okay. So in order to do that, I love this quote. The ability to ask the right question is more than half the battle of finding the answer. I had always had this attributed to the Army, but I investigated it a little bit and found out it was by Thomas John Watson Sr. If you don't know him, amazing man. He was born in the around 1890, and he tried a lot of different things. He was a teacher for a day. He was a salesman. He worked in a painting company, and he tried all of these things for a day and saw all of these different businesses and realized, okay, there has to be a better way to organize all of these different companies. And so then he founded the International Business Machines, which you might know of as IBM. He was one of the richest men in the world and was known as the best salesman because of this simple rationale. He wanted to ask the right question. And so I feel like that's where we're at right now in the online dispute resolution world. What is the question? What is it that we are really trying to do? And I think the more we can simplify that down, then the more effective and satisfying it is for our clients, right? Because if we know what we're trying to do, then that is reflected back to them. So for me, I believe that what we are really trying to do is help our clients to fix problems. And everything else that we do should support that, okay? So again, I think that that's what we're trying to do at mediate.com. Obviously, that question might be slightly different where you are, but I think for us, the more we can get back to our vision of how can we help our clients fix their problems, then that guides the rest of our development. Okay. So when I'm thinking about a simple process, I as a client or as a mediator, want a caseload management system that allows me to do everything that I can do on my phone, right? If I can do it on my phone, I should be able to do it in a caseload management process. So for me, that boils down to 5 main things. Intake. Like I said, if we want this to be a simple process for our clients, that means I have to just have a few fields. And as you can tell, I am someone who likes to talk. I like to ask questions. So this is very hard. This is showing a lot of restraint to say, okay, what are the 5 main fields that I want to put in an intake process? Keep it as simple as that. Scheduling. I should just have to send my clients one link. If you're sending them lots of different things, it's confusing, it's overwhelming, it's adding frustration to an already frustrating process. So I create as simple of a scheduling process as I can for my clients. Meeting, again, let's keep this clean. Let's keep it very simple. Often I'll include some kind of an FAQ for my clients and let them know, this is the process. We are going to sign on to Zoom. We are going to resolve our dispute there, and then we're going to have a document here. And I am thinking through this process again for my clients, and I'm constantly thinking, what can I cut out? And I think the more we are thinking that and just getting back to our main question of how can I help clients the most, then it's more of a satisfying process for them. When we're thinking about payment, of course, that should be a known platform, something that they trust. And for forms, again, I just want to send them one link. And so I just want to reiterate, the simpler process, the more satisfying it is for clients. I want it to be a very clean process so that they can just focus on the actual issue instead of having to think about, okay, first I have to log in here, and then I have to log in here, and then I'm going to have to upload something here. No, we want it to be as streamlined and ideally as integrated as possible. Okay, so let's get into some actual specifics here. I wanted to make we wanted to make a very simple process for clients. And the way that we continually checked that was I would log in as a client and just continue to think through, where is it confusing? Where does it feel like there's a potential hiccup here? And so walking through that process as a client helped me to see where are some areas that are not simple, where are some areas that have become too complex, so it is not a straightforward path for the client. And as I did that, I noticed that as a client, I wasn't feeling that same sense of safety that I was when I was more on the design end. On the design end, I've had thousands of conversations with our designers and developers and programmers. I know how safe and secure this system is, but I needed some way to communicate that back to the clients, that the clients could experience that same feeling of safety, okay? Because let's face it, safety really is the foundation of dispute resolution. If, I can't imagine having an argument with Colin, but let's say I'm arguing with Colin about something. I would need a safe place to be able to talk through that, right? A safe place where I feel comfortable expressing my concerns. And if I didn't feel like it was a confidential place, if I didn't feel like the mediator was securing and protecting my data, there's no way that I could be vulnerable enough to express my interest and make any progress. So we know as designers that we have created a safe system, but we also need to find a way to communicate that to clients so that clients understand how safe these systems that you're designing truly are. So to do that, I am seeing three main areas that we have to think about data security, and not just on our end, again, as the designers, but also communicating this to the clients. So this might mean having a web page, having a privacy policy, having an email or some kind of a chat room, some way to communicate this to your clients that you are protecting their data in three unique areas. First, where they're actually inputting their data. Again, this is usually an intake form instead of an email because we want it to be encrypted. This could look like digital voicemail. We want to make sure that we're only getting their necessary information. And after you receive that intake, then ideally they can sign up for some kind of a digest so that they can log in and see any updates to the system. Again, this is instead of you sending emails back and forth. Because depending on your system, again, that email might not be safe. I know Herb's going to go into that, so I'm not going to spend time there. For storage, we want to let our clients know where is that data being stored. The reason why this is really important, imagine that you are an ombud at a company and a person has a complaint with their IT department. And so they're putting all of these complaints in about the IT department, which the IT department can then go and see, which of course is going to make the client feel like they are not safe, like they are not able to, like they're not able to be vulnerable. So this is the second thing that we need to communicate to our clients. Where are we storing that data and how long are we going to store it? During the meeting, we also want to let them know that we're keeping that data safe, but that we're also making sure to protect the meeting itself. So this is where we can talk about end-to-end encryption, okay? And again, the majority of video conference platforms have that now. So that should be a no-brainer at this point. Okay, and then finally, for sending data back and forth, we want to make sure that we are protecting their data from start to finish, right? So not just protecting it during the input process and the storage and meeting process, but that we are being just as safe during the sending process. So if we have to send a document via email, let's make sure to password protect it or post it into a safe place.
For a short time. He's always concerned about where she went.
Colin, thank you. Thanks so much. All right. And then I'm going to fly through this part really quickly. So I posted a few things on here for anybody else who's going through that same dispute resolution system design process that we went through. Here are some of the pieces that we had to consider to make sure that we were keeping track of our clients' data, that we were keeping it as secure as possible. And so for anybody who's interested, I have a few slides that are on this just to make sure that you are thinking through those same checkpoints of making sure your data is secure as possible. Obviously, of course, we'll begin with GDPR, the General Data Protection Regulation. This talks about how any personally identifying information is handled, okay? For some of us, that can be addressed with a privacy shield. So that's if we are transferring data back and forth to the EU. Then you can simply self-certify and say that you are a member of Privacy Shield. But there are quite a few organizations that are saying Privacy Shield isn't enough anymore. And so they're starting to look at other types of regulations for saying that your data is secure, that you are a trusted software. One of the more interesting ones that I've seen is CCPA. So that came out in January, and this was California saying, here are all of these different types of identifying data, and here's what you're allowed to do with them. And what's interesting is it holds a company accountable for not just what they are doing with their data, but it also forces you to be responsible about who you're sending that data to and investigating what they're doing with the data. So for instance, at Caseload Manager, if we are creating a handshake with a court system, then we need to go out and be responsible to find out how that court system is protecting somebody's data. Because if they're not in compliance, then it shows that we were not being responsible. Okay, so this is interesting. It goes a little bit, it's a little bit more far reaching than some of the other regulations that we've seen. Okay, so again, just putting a few things on here for you, for those who are just going down this process, and then I'll hand it over to you, Herb. So things that we have looked at to increase security with our system, of course, multi-factor authentication. That can be a text, email, a call, or a push. We've also looked at timeout. As we all know, timeouts can be really frustrating. So I think it is important to allow the client to determine when they want that timeout to be. Should it be every 2 minutes or should it be every 30 minutes? And then what happens after someone is timed out? Smart passwords. I love it when companies require strong passwords, but I hate it when they don't have alerts to change them frequently. So I think it's important to have both. And then, as I said, also make sure to protect things with a password. Protect your documents with a password, protect meetings with a password. Okay. This just describes the CCPA rules a little bit more, exactly what they determine to be that personally identifying information. And as you can see, most dispute resolution systems are going to be taking that sensitive information, because that includes things like any personal characteristics, any employment or education data, and we often see that in grant requests. So this means that as a dispute resolution system provider, that we are beholden to these rules. We are a company that is seen as handling sensitive information. So all of that to say, we know that we are handling sensitive and secure data. And in order to protect that data, we need to do two things. We need to tell our clients how we are protecting the data. Again, we're going back to reinforcing that feeling of safety for our clients. And we also need to take responsibility for finding out what our connected platforms are doing to protect that data. Okay, so that's the main summary from here, is that in order to have a safe process, you need to make sure to protect the data coming in, the data being stored, the data during the meeting. And again, if there's additional data that's being stored during the meeting, we need to think about that. And then finally, what data is sent to other platforms. And if we can communicate to our clients how we are protecting the data at these key points, then it reiterates that feeling for them of, okay, this is a dispute resolution process that I can trust. Okay. And for smart software, again, this is where Herb's going to take over in just a moment. We just want to think about software that is actually supportive. There's a reason why we call it a platform and not a canyon, because it should be there to save you time, right? It should be something where you can design your own fields. I said in the beginning, we tried to design one perfect system for every office. What were we thinking? No, every office is completely different. So designing a system that is responsive, where people can add features or remove features, add people, take away people, set up a lot of different bells and whistles and connect with other platforms. That's what is required now for making tech smart, for making it something that is actually sustainable. Okay. So again, that's my very quick and dirty summary of, as we have been designing dispute resolution processes over the last dozen years, we tried a lot of things that we have since abandoned, and we have really come back to the question of how can we make this a simple, safe, and smart program? Okay, Herb, I will now shut up, I promise, and I will hand it over to you.
Thank you, Claire. Excuse me. Yeah, I don't know if I'm going to be, I don't think I have control over the slides. So I'll let you worry about that, Claire, if you don't mind.
Sure.
Hello, everybody. Herb Way. I'm the Ombudsman at the Internet Corporation for Assigned Names and Numbers, or ICANN. Probably many of you may have heard about ICANN in the past because one of your associates, Frank Fowley, was the original ombudsman. But basically what we do is we ensure the stability and the security of the DNS system, which is basically the foundation, the backbone of the internet, so that all the protocols and the policies are all consistent globally, so that when you type in a domain name, it converts to an IP address, runs through the internet from wherever you are to wherever the destination is, and then converts back into from a domain name typed into the computer to an IP address or a number, and then deconverts back into an IP address into a domain name at the destination. This requires a global consistency in the routing and so on, the servers, the switches throughout the globe to the devices, so that they all work on the same platform. Now, it's a bottom-up community-based multi-stakeholder model, which means that ICANN, which is an organization of approximately 300 and some employees, governed by a board of directors, implements policy that is developed by the global community in the running of the internet, so that there is input from the 5 regions of the world, the internet being divided into 5 regions. Our headquarters is in California. We have employees throughout the world. We have regional meetings, well, pre-pandemic, but hopefully we'll be getting back to our regional meetings 3 times a year that rotate through the 5 zones, so that community members from the various zones have an opportunity at least once every 12 to 18 months of attending face-to-face ICANN meeting, where they can discuss policy development and some of the hot topics that are happening in the internet. As ombudsman, my jurisdiction is over actions and inactions of the board, the directors of the organization, the officers in the organization, and also between community members. There are multiple community groups, stakeholder groups, and advisory committees that have leadership teams. And they all have I won't say personal agendas, but they all have agendas that are specific to their stakeholder group or advisory committee. And those are often conflicting, depending on whether they're focused on human rights or inclusion or profit or nonprofit or whatever their agenda may be. I also promote the expected standards of behavior for the community and the organization, and enforce a community anti-harassment policy. Next slide. So when the office was formed back in the mid-2000s, there was a complaint management system that was developed for the office. And over the years, it worked, perfectly well. But then it became it got to the point where it could no longer be supported by current IT technology. So one of my first priorities when I became the ombuds a few years back was to implement the new case management system, and that's where Claire and Mediate.com came in. Working extensively, of course, because being run over the internet as an ODR service to my community, the IT department knew just about everything they needed to know about security and stability of a system and some of the challenges and things that needed to be looked at running a system over the internet. So that was probably one of the most challenging aspects of getting this up and running, was making sure that mediate.com met all of the stringent requirements of the corporation that runs the internet. One of the critical components to running an ODR service is having a good, solid, easy to use website. So my website is easy to get to on the when you go onto my organization's website. And once you're on it, it offers easy access to some of the services that are required by the complainant or the person visiting the sites, such as an easy one-click access to the complaint form, which is directly linked to both the web page for the organization and to my email system. So that an interesting difference between the old complaint management system and the new is that the old complaint management system automatically generated a case number. So it was prone to spam. Anybody that could develop a spamming program to interact with the case management system could easily overwhelm it with multiple complaints. So now the only thing that will get overwhelmed after there has been a manual input of information into the complaint form is my email inbox. So there's an interface between the complaint form submission and the logging into the case management system manually by myself. It's a little bit time consuming, but it does prevent the problems that come with having a direct link to the system. The website also has, of course, some interesting information for the person visiting. The framework for my office and its management, a logic model that explains the complaint process and some of the information required for that, links to news and speeches and videos that are put up over the years, self-help facts so that they can get a little bit of information before they actually log a complaint, and of course links to social media. The next next page, please. Now, if you are going with a complaint management system, one of the critical points I think that you need to look at is if you are required to publish an annual report, that you make sure that your complaint management system is user-friendly for somebody like me who is completely non-tech savvy and knows virtually nothing about Excel sheets and migrating data and so on and so forth. So you want to use something that is easy to use and easy to learn, so that somebody like me can take the information from the case management system that's collected through the year, work with it, and develop a good, solid annual report, which is sometimes one of the only ways that us dispute resolutioners have of communicating to our organizations or to our communities or our clients our value. So just to give an example of last year, which is the year that ended in 2019, the last annual report, 164 logged complaints. So that's 164 complaints that came into me and were logged by myself into the complaint management system. So that gives you an idea that having that interface of myself between the intake and the logging is manageable. If I was running a government agency, for instance, that had a legislated ombudsman, then it might be a little bit different. I may at that point be required to have an automatic complaint management system that logs the complaint, and of course build in the necessary requirements to keep it safe and secure so that it doesn't get spammed. The online complaint form was used 37 times through the year of the 164 log complaints. Social media, interestingly, 5 times. People would reach out to me over Twitter, Facebook, or you know, at which point I would ask them to fill out a complaint form and send them to my webpage. Emails is something that is probably the most used, and I'll get to that in the next slide because it's something that is worth talking about for a few minutes when it comes to confidentiality. Interestingly, also at the bottom there, complaints came in from 30 countries globally in the 18-19 fiscal year. Next slide, please. So your culture is one of the most important aspects of running your case management system and your online dispute resolution. You have to know your people. In my environment, email is an acceptable form of communication. A lot of the ombuds working through the world see emails as a taboo place to go because what it does is it creates a record. And I recall meeting the ombuds for Coca-Cola many years back who didn't even carry around a pen, and his entire office was paperless. But in my community, email is an acceptable risk. They trust the confidentiality of the office, and they understand that there's no guarantee that if somebody decides to publish something that I've written or that they wrote in part of an email exchange with other people, they take that risk and they understand that that can happen. It's happened 1 or 2 times over the years where something slips out and it creates repercussions and trust. But it's again something that my community learns to live with, and it's interesting because doing most of the work by email, it allows me to learn how to read tone, and so I can understand when somebody is. I can see when somebody is being sarcastic or being bitter, and that helps a little bit. And email is also a great opportunity in my environment where it's primarily shuttle diplomacy to reflect. So it gives me the opportunity to stop and pause and think about something for, you know, an hour, a couple of hours, or maybe a day before responding, which is an interesting aspect of online dispute resolution, and I think one of the probably most beneficial. Unfortunately, there's an eternal record of everything that is done in this type of online environment, at least in my experience. GDPR, which is the European data protection regime, plays a big role in some of the things I do, what I can save, what the case management system is allowed to log and register, and plays into the data retention policy, which for now, for my organization and the Ombuds Office, is pretty much eternal. Next. So there's my information. I believe these slides are going to be saved for everybody. Anybody that has information, questions or requires maybe a little bit more clarification on some of the points. So just in closing, I think probably if you are going to be developing a case management system for your online dispute resolution practice, and you are going to be doing, whether it be mediation or ombudsing, and you're not going to be using AI as part of your thing, but actually using it as a nuts and bolts case management system, make sure that you work with your people that are developing it and implementing it so that it fits your environment. And again, probably as Claire said earlier, keeping it simple, keeping it safe, and making sure that it's user-friendly is important. Thinking back to the previous presentation of making it accessible for people with disabilities, one of the issues we bumped into about a year or two ago was my case management system form required a CAPTCHA before submitting it. And the CAPTCHA was not something that somebody with a visual disability could work with because they could not see. So the CAPTCHA had to be changed to make it more accessible for everybody. So things like that you have to be able to work with your developer. And I think there's 3 or 4 minutes left. So if we can open up the floor maybe to questions. Thank you. And if anybody has any questions for either of us, now would be a good time. Thank you.
Thanks, Herb. And I want to say it was an honor to get to work with her, because I have spent so much time looking at how intentionally ICANN has designed this process. And so if you do want an example of a very simple and safe and smart approach to online dispute resolution, I highly recommend visiting the website he's put together. It describes everything so clearly for his clients. And it's a very simple process that I think is reassuring from start to finish. So, yeah.
Great. So any questions? Anyone want to raise their hand or unmute to ask a question of Herb and Claire?
Hi, Ethan.
Ethan, please.
Okay, I'm sorry for the delay. Herb, I just was curious whether your office still handles uniform domain name process complaints.
It depends. No, I would probably say no. Are you referring to the ones that people would file with WIPO and stuff like that? Or
well, my knowledge of this ended about 15 years ago, but at that time, one filed domain name, trademark disputes, domain name holders, registrants. Those were handled by ICANN's Uniform Domain Name Policy, UDRP.
Yeah, there's various accountability mechanisms in ICANN. The ombuds is one of the 3 accountability. We also have like a reconsideration request process that looks at board and organizational decisions. And then there's an independent review, which is it's conducted by an external arbitrator system. Generally speaking, trademark and copyright and things like that now are, it's primarily the registrars and the registries that have control over protecting domain names in that regard, including with the new generic domain name opening up of basically you can register now just about any domain name as you want in the top level domains. But it still has the option, if there is a complaint about trademark or copyright, ending up with WIPO on the international scale, yeah. There's policies and protocols now in place that protect domain names from being abused, in particular with the generic top level domains. That came about probably in the last, I would say, 10 years with the running of the new GTLD program.
All right, thank you.
Jeff, I see you have a question.
I have a question for Herb about the multi-stakeholder community member process. How do those communities form, or how do you form them, and how do they communicate with each other and make policy recommendations? Do they use online formats, or how does that work?
Yeah, there's a set structure for the internet community multi-stakeholder model. So primarily the policy development is the GNSO, the generic name supporting organization. They consist of the registries, the registrars, intellectual property. They have law enforcement. They have the non-for-profits in there, the end users. They work together in their individual little silos and then come together when it comes time to develop policy. So the policy funnels up to the top of the the GNSO. And then once it's been determined and approved through consensus, it's given to ICANN to implement. So if there's a change required in some technical aspect of it or some global aspect of it, then ICANN will, the organization works on that. There's also advisory committees that are part of that structure. There is a technical community that oversees the functioning of the technical components of the internet. There's a government advisory committee that represents governments globally that comes to our meetings and works together in their structured silo, reviewing policy development and the impact it will have on their individual countries. There's a country code silo where all of the country code developers and implementers, such as CIRA for Canada, that operates the .ca. So it's a structured multi-stakeholder community, and each of these members, each of these groups in the multi-stakeholder member structure nominates members to the board of directors, which oversees the entire global community and the organization. So there is a type of org chart, if you wish, that shows this available on the ICANN website. I don't have it in this PowerPoint presentation. And anybody, it's open to anybody that's interested in participating in policy development for the internet, or has concern about either regional, national, or global internet policy, is free to participate. All you have to do is either contact your local chapter of the Internet Society or the local ICANN regional office, and they can guide you in participating as a community member.
Thank you. Wow, Herb, that's a complicated organization to be ombuds for. So you got your work cut out for you. Actually, I was just about to say, Claire, Despina asked a question that's mainly for you, but you've responded in the chat. I don't know if you want to speak to it as well about data storage and how long you hold on to.
Sure, I know we're at times. The short answer is you really have to work with every organization to find out what is their appropriate answer for storing data, simply because for most courts and community mediation centers, they want their data stored as long as possible. They want to be able to analyze trends and see over time what cases are improving and where is room for efficiency. With many ombuds offices, it has been exactly the opposite, that they want their data deleted as quickly as possible if it's any personally identifying information. And they want to retain the demographic information and the case information if that can be done in a way that still protects the clients. And so we've had to come up with two options. One that stores data for trends, again, demographic or case data. But if there's anything identifying in there, then a lot of ombuds offices want that to be deleted, even scrubbed from servers within a few days. So, absolutely. Yeah.
So, I think to tie it back to Jan's great presentation that sort of opened up the day, I really think that, what Herb and Claire are talking about is really creating a practical blueprint, implementation blueprint out of the framework that Jan was sharing. And just like Frank Sander used to talk about, we have to fit the forum to the fuss. I think we have to fit the systems design to the caseload. And I think it's a very interesting thing to take all of Jan's considerations and put them into a step-by-step process where you can design and implement software, and then go back, as Jan said, to look at the goals. What were the goals we wanted to achieve? How can we measure? How can we look at the data being generated to see whether or not we're doing that? And I think one of the reasons why the dispute systems designers have always gotten ODR first is because they understand that ODR, building an ODR system, is making dispute systems design real in code. So I really do feel like this presentation was a great tie-in to the theme of the day. So any last comments that anyone has for Herb and Claire?
Thank you, everyone, so much.
Yes, let's please give a round of applause to the two of them.
Thanks, Herb.
Great presentation. Great presentation. Wow, what an incredible morning. So we just have a couple things we want to touch on before we break for our middle of the day lunch. Is Brian Hutchison on the call with us? I didn't
I'm
see
here.
it. Ah, great. Excellent. Please, let me hand it over to my good friend Brian to talk about some exciting plans we have in store. Are you going to present any slides, Brian? Do you want me to?
No, I'll spare you seeing any slides.
Okay.
And I'm going to ask you to use your imaginations and imagine a lovely Irish scene behind me, as I once again have the privilege of saying hello to all of you. So nice to see your faces, and I'm playing catch up with the recordings. So I gather there's been quite a lot of interesting topics and ideas, both discussed and shared today. And you know, it reminds me that it was October 2019 when we last had the opportunity to do this in person. I'm delighted we had the opportunity to do this online, but I'm here to say a few words about hopefully the next time we will do this in person, which hopefully still will be in Dublin, and ideally this year, and if not very soon afterwards. So let me say a little more. You might recall we were to host the ODR in Dublin, the ODR Forum in Dublin in May 2020. ODR 2020. And I can remember even this time last year, sort of still wondering if there was a slight chance we might be ready to do it by the 5th and 6th of May, but how time has made us all the wiser. Nevertheless, we're still very committed to welcoming you to Dublin for the next forum. And we have made some tentative moves to book ourselves a time slot in our venue at the University College Dublin, Sutherland School of Law in Dublin. So the dates we have penciled in will be the week of the 11th of December 2020. So that's very close to the end of this year. And we're going to play a watching brief, if you will permit us, so that we can make perhaps a better call on this towards the end of May. It would give us a 6-month run-in for the event. How things stand regarding Dublin generally in December, in any December, is that of course it's the lead into Christmas. It's quite pretty. There's a lot of excitement, and of course Ireland being a place where people like to celebrate music and culture and dance and so on, Christmas can be a very exciting time. So I can guarantee you that if we are free to enjoy the place, there will be much enjoyment done. And of course, for those of you who are coming to Ireland, perhaps for the first time, being a relatively small and accessible country, our hope is that you will be able to take advantage of it to travel perhaps to Belfast, or to use it as a springboard for a trip to London or Paris or the other wonderful delights. And of course, for those of you who are coming from Europe, well, welcome back to Dublin, as the case may be. But you're probably wondering how we're fixed as regards pandemic and regulations, etc. Well, in Ireland, we've taken a fairly conservative approach, which has been fairly successful as much as any. On the other hand, we still are in the process of maintaining pretty close, state close to home 5-kilometer restrictions. Our numbers of infection are not low, but they are not high. And we are in the early stages of a vaccination program. And really, that's the point that I want to make. It's that, with a population of only 4 million, it won't take us long to get everybody jabbed. My own dad just called me to say he got his jab today. So if I seem a little happier than the last time you saw me, that's possibly why. But we don't know yet for sure whether we will have restrictions on large number gatherings by December. And that's really the critical thing that we are concerned about, because I don't need to tell all of those of you gathered that while we recognize the value that online interaction brings and how it can make dispute resolution and life better, we also cherish the opportunity to exchange face-to-face and in person. And I've enjoyed many of the times doing so with you in our adventures around the world, and I'm hoping that Dublin will be the next chapter. As regards the forum, the website contains the invitation. Those of you who are registered continue to be registered. Please don't hesitate to contact me if you want to change your plans or seek a refund at any point. That's easily done. For the event itself, my guess is, and today confirms, that we will be bang on target with our original themes of justice in online dispute resolution, of new and developing technology, of ODR and the courts. And of course, my expectation is that the rest of humanity, which has been dragged online after us, will have high demand for knowledge in these areas. So I would be hoping that our first opportunity to meet in person, which I hope will be Dublin in December, as I say, will be an opportunity for us to bring across and to make a stamp, if you like, on the field of online dispute resolution, particularly from the perspective of justice and standards. And now that people know what's ahead, that we will have an opportunity to show them perhaps what they need to consider in order to make ODR a more just proposition. And so I really welcome the opportunity to invite you to Dublin to do that and to share ideas, to influence those around us, and perhaps to make ultimately the world a better place. What happens if we don't meet in Dublin? Well, our next vision for Dublin would be spring of 2022. Can you imagine that, spring of 2022? Why I say spring is, well, it isn't harsh conditions in Dublin in January, and it isn't harsh conditions in Dublin in February. In fact, you can get nice sunny days, but the days aren't long. You don't have the atmosphere of Christmas. And, it would be nice to share some longer evenings, basking in the long evenings that we get towards March of 2022. But plan A, please, just a note for your diaries for now and a watching brief, as I say, ODR 2021 Dublin. And yes, I did go and get the URL for ODR 2021 as well.
Notice
and
that.
You've just reminded me I better get 2022 now also.
Well, the other thing, first of all, Brian, thank you so much. We're very excited. This is going to be a celebratory forum because we're all going to be able to get together for the first time in several years. And we appreciate you hanging on. Hopefully, we're all going to be jabbed by December, and then we can all meet there and celebrate over a Guinness. We also have behind this one, Amayu Watanabe has volunteered to host the next ODR forum in Tokyo. So she will patiently wait her turn as well. So fingers crossed for all of it. But thank you so much, Brian. Here, let me share my screen quickly just to make a couple more points before we break. Brian has the website here, ODR 2020, up and running. And if you go to odr2021.org, it actually goes to this website as well. So stay here for more information, week of December 11th. That's what we'll be aiming for. Let me just mention two other things before we break. The first is ODR Expo Tech. Let me share this quick video. Let me make sure that I'm sharing my sound here as well, just so that you can hear it, because yes, I am. Alberto is hosting a meeting at the end of April, so take a look at this.
ODR Expo Tech, el encuentro más esperado en el mundo de la resolución de disputas en línea. 5 días que cambiarán completamente tu forma de pensar sobre la resolución de conflictos online. Expositores destacados de 5 continentes, charlas inspiradoras en 3 idiomas, traducción al portugués, inglés y español, 20 talleres interactivos, 15 demostraciones tecnológicas de vanguardia, espacio de networking, sí, networking en directo, con reuniones de la comunidad online abierto las 24 horas y mucho más. Un evento disruptivo y revolucionario como ningún otro que hayas vivido hasta hoy. ODR Latinoamérica, siempre un paso adelante.
So I think we can all agree that we are definitely going to want to attend the ODR Expo.tech conference. It's happening in 54 days. I urge you to visit the website here, odrexpo.tech, 50 experts, 20 interactive workshops. I mean, it's going to be amazing with tons of tech demos, many sponsors. You'll recognize NCTDR and Icodr and many others. And these are just some of the presenters. So please put on your calendar end of April if you can join. I think it will be well worth your time and attention. And the last thing I'll mention is for our good friends Binek, Lobel, he sent over some slides about an ODR track 2-day conference he is running as well in November. You can see it's an annual international conference on selected ODR topics. So we're going to be doing quite a few exciting events as part of this as well. So as you can see, our dance card is already quite full with ODR events through the spring, summer, and fall. But hopefully we'll be able to all get together in person in Dublin come December. So any last comments from anyone? Let me stop my share. It's been a wonderful morning. I highly encourage all of you to rejoin us this afternoon. Our kickoff presentation in the afternoon will be with 2 researchers from the University of Arizona. They are some of the recipients of the Pew grant money doing empirical longitudinal research on ODR court effectiveness. This is the first time any of this research has been shared publicly. So this is going to be a pretty exciting event. So I highly encourage you to join us again, 4 p.m. East Coast time, 1 p.m. West Coast time, and then we've got a bunch of other great presentations, and then we'll wrap it at the end of the day with Ethan. So any last comments? All right, with that, thank you everyone for a wonderful morning. Have a good break, have a nutritious lunch, get some rest so that you can come back and we can finish strong through the afternoon. Thank you everyone, take care, and we'll connect again in a few. Okay.